May it please your lordship. Lordship, I beg to mention item number 13. Probably lordship may not taken up this matter during trial. Lordship has recorded the statement of the evidence of the
1-3.
1-3 lordship.
The matter of 2023, let the matter be listed after 2 weeks after vacation.
After vacation, lordship. In the meantime, lordship, LCR may be called for that. Is
After vacation, that's the call.
highly obliged.
May it please your lordship. With concern, I beg to mention item number 6, your lordship. Let it be after the vacation, your lordship.
Item number
6. I've taken the concern of the other.
for the petition.
And for the petition, your lordship.
Your good name?
A. Das, your lordship.
A. Yeah. After vacation.
After vacation. Much obliged, your lordship.
May I please, your lordship. Your lordship, I beg to mention item number 29, your lordship. The matter may be passed over for the day, your lordship.
29.
29.
29 was the hearing matter.
Yes, your lordship. Only for the day, your lordship. Some personal difficulties are there. I love it.
Maybe.
People listed for fix and it after 1 week only. After
May please, Your Honor. My lord, I beg to mention item number 4, my lord. Kindly pass over to the day, my lord. I have taken the consent of the other side, my lord.
you are Mr.
M. Hussain, my lord.
M. You have taken consent of that
Yes, my lord.
for the day, then it will be definitely after vacation.
My lord,
It will come after vacation.
my lord, next 110, my lord, in trial court, next date, my lord.
110.
Yes, my lord.
But
Before any date, my lord.
before
110, any date, my lord.
who did? After 1 week.
Most obliged.
May it please the lordship. I'm praying for a listing of bail application for hearing matter. This matter has been tied up with this bench.
Better to approach gracefully. In fact, it is not regular bench. That's why I am not.
Actually, my lord, this matter has been tied up to this honorable court, man. It was earlier.
Okay, well, you approach the ST will give it to maybe my Monday also. Maybe. But please the matter before ST, yes, because I'm not taking the regular bench. That's why only. Otherwise, no.
Still, our
It may
difficult.
come before this court only.
Yes, yes.
Yes. But I cannot just approach it to ST.
May I please, lordship. Item 30, lordship.
Hmm.
After vacation, lordship.
You're appealing for Mr. M. Khan.
Yes, lordship.
After vacation. This when he is in custody.
Lordship, arrest on 31/3/2024.
31.
Lordship, today 194 days.
It is a charge sheet case.
No, lordship.
Huh?
Lordship, yes.
Charge sheet after vacation.
May I please, your lordship. I beg to mention item number 21, lordship. Matter may be adjourned for 1 week, lordship. Charge sheeted bail application
For 1 week.
for 1 week. Obliged.
So I can go.
May I please, your lordship? I beg to mention item number 24, 25, and 38 from supplementary list. Only matter may be adjourned for the day.
24, 25,
And 38.
8.
Matter may be adjourned for the day.
Otherwise, most probably the welfare has 10 copy of welfare has already been received. Okay, so I'll be listed after one.
Publish.
May I please, Your Lordship? Lordship, I need some accommodation in item number 23. Kindly the matter may be adjourned for the day.
23. Okay, take the order
Lordship, fixed after puja vacation.
after vacation. The request to- Is it certificate?
Yes, Lordship. Problem.
May I please, Your Lordship? I beg to mention item number 42, passed over the day. I'm on interim.
Yes, 42 have you received? Yes, right? Not received.
No.
You are on interim.
Yes.
Interim was there.
My lord, perhaps not. Oh, yes, interim may be there. my lord. After vacation, you know,
It's according after vacation. Any date? Any date after vacation?
my lord,
Any date? 24
May I please, Your Lordship? Lordship, I beg to mention item number 8 and 9, Lordship. Lordship, I have taken concern of the other side.
Yes. It's a criminal petition.
Yes, Your Lordship.
You have taken consent of the other side. You're for the petition.
Yes, Lordship. One matter is I am the petitioner and other is the respondent, Lordship.
You are Ms. Esda.
Yes, Lordship.
Eight.
If matter may be taken up before vacation.
Before vacation may not be possible. Before vacation it may not be possible. Definitely it will be after vacation. After vacation. In one item number 8 is for the petition. And the item number for
May it please, Your Lordship. But I beg to mention item 28 of today's supplementary list. But I am praying that kindly the matter may be taken up after vacation on 24th of October, because similar matter has been fixed on 24th of October, my lord.
similar matter.
Yes, my lord. And the CD has also not been received along with the FSL, so reminder may be issued, my lord.
Did you not receive?
CD not received.
Yes, that's CD. What about 20?
no, perhaps CD will scan copy call question.
No, no, CD, not certificate matter.
20 episode.
What nature of case?
NDPS matter, my lord, commercial quantity.
So since when he discussed it?
Yeah,
Yes,
I don't know the exact, it will be around 100 days, my lord.
20.
my lord, CD is not received.
CD and FSL. Both CD and FSL was all right.
Perhaps our CD is not filed.
On 24th, my lord, October.
Commercial quantity.
Commercial quantity, my lord.
You were on 28. Huh?
28, my lord, 28.
They did not issue remand. Call for it along. List on 24. They are listing it on 24.
Obliged.
On 24 October.
24 10 after vacation.
My lordship, my lord, this is bail matter. It is bail matter, so it may kindly be listed on Monday for motion.
Actually, what is happening is not regular bench. From Monday, again another bench is there. I'm not sitting.
The matter will go to that bench.
No. It's one thing of it. As I'm not taking regular bench, it's approved registry that can do. Monday maybe. I'm not in a position.
May I please, Your Lordship? Lordship, I beg to mention item number 36, Lordship, supplementary list, Lordship.
36.
36, Lordship.
38,
36 Lordship.
36.
Yes, Lordship.
Hmm.
Kindly matter will be adjourned for a day, Lordship. The engaged counsel have some difficulty in
Who is your engaged counsel?
Lordship, SB Laskar, Lordship.
Engaged counsel is SB Laskar. Laskar is it? So, good job, Nalak. After one.
May I please, Your Lordship? Your Lordship, a victim mention item number 22, Your Lordship. Here in this matter, Your Lordship, we have filed one additional affidavit, Your Lordship, that is not on record, Your Lordship.
What call it today? Today,
Your Lordship, after vacation, immediately after vacation. I
You
think
are
there is some defect in the affidavit. That's the reason why it's not.
additional affidavit.
Yes, yes. Even number 40, 22.
22. So your good name?
IH Laskar.
22.
But I H. It's something. One, right? At the other subject, okay, it will be this after.
Hello.
Position in 11. Last occasion, reminder was issued again.
My lord,
And then now,
perhaps the rust report was called for by on last occasion.
yes, status report was also called.
Yes, we have not received anything.
Status report is not received. So this is the case of against the NPS matter or what? In the case of NDP,
NDPS case, my lord,
no.
Commercial
Yes,
bank.
yes. Apart from NPS, there's some other sections are also there.
yes, other sections of there, my lord.
When is it?
Let the status report be, let a reminder be issued for status report. We sent our message on 9/9/24, 9th of September. 10 days gone, my lord.
And it also- that- that it is not it to it on time. If the matter that it is custody most of this 2022. So we can that be better to give a date.
My
It's
lord,
in custody since 2022.
my lord.
So after vacation,
After vacation, my lord.
any date after
24th of October, my lord.
here also we have received the
Nobody appears, my lord.
copy,
My lord. Scan copy is there,
can copy.
but nobody is there for petitioner. Let it come some other day, my lord.
Service on the response number is not yet the last occasion, that is on 3/9,
My
there
lord.
was an order that the notice to be issued on victim public guardian
My lord.
because it is the POXO, I think.
Oh, POXO is there. Now, whether steps have been taken or not, my lord.
not been received. No non-application call for debate. This is related to this case, but this report is there already. Oh, that has already been non-application call for debate. Can copy the debate. However, it is that as per order date 29/2024, the district of Adak takes but from the office note dated 29/2024 that the state of response number is not yet with additional record of the matter. Okay. Yes. Okay. But of 26. It's not that I think here to the position Mr. Dasik is notified the morning of 40, 27, 28.
For supply.
Supply 27, you are here? Okay.
May I be pleased, Your Lordship? Matter may be taken up at 2 p.m., Your Lordship. My seniors in legs in court number 2.
PM.
2 p.m.
Okay.
Much obliged.
This is the case of NCB, I think.
My lord.
Guru Night. Here, have you received the test calendar? None of it. Not it.
31 NCB is there. We are not there.
We are not.
31, 32 NCB is there.
The can put the yes, what the this is the method for 1. With the same order. 32 is there anyone?
Lordship, matter may be adjourned for today.
Why?
Our senior counsel is not available.
Finding as batia. मैं दुनिया की सबसे पता है. पासवर्ड खोल दिया. पासवर्ड खोल बोला. फोन पर
Yes, Nawaz. you are
Well,
going
one
to-
thing was there, my lord, they were supposed to file an objection to our bail application. That has not come on board. That may be reflected in the order that if any objection is to be filed, that may be filed by the next day. It's not reflected in the order, my lord. But then
they are supposed to file an objection.
they submitted, my lord, when the case came up for motion, that they will file objection. So, my lord, if they are inclined to file, they may not file also, my lord. That may be reflected.
Yes, Nawaz. And hopefully, hopefully, and it is that one. Okay, it is that the concept of the people that they are going to submit the object. one more chance. File. When it can be listed.
My lord, as per lordship's convenience, my lord. Commercial quantity, my lord, so there is no urgency
To vacation then.
after vacation.
Any date.
Deeply obliged.
Sorry, my lord. Item 31, my lord. Item 31, can it be passed over for time being, my lord, if possible?
No, I have already. Other side NCP is also not there. That is the problem. So it should be listed after one.
Date may fix before vacation. Date
You want any date?
Yes.
After vacation?
before.
Before? Before? Possible, not possible.
I think it was a BA. Any
No,
date
BA,
before.
it's a commercial quantity. I think.
Commercial quantity. This is not my case.
Let it be after vacation, I'll give you a date. But not before vacation, maybe not possible. Earlier order was after 1 week. If you are 1 week. Three, 310 will be.
See?
310. 310. Here date is not. Your PP is there.
My lord,
Same commercial quantity.
commercial quantity.
Charge sheet matter.
And armed safety is also there, my lord.
Charge sheet case.
My lord,
Charge sheet case.
certificate case.
After vacation.
After vacation, my lord.
After vacation. What is that? It was organized in night itself. It was not there. Anyway,
This is also a commercial quantity.
it's not charge sheet one. It is
Charge sheet is not there.
because all the FSL report along with the case diary was called for.
Yes, yes. We sent
Person
message,
is
my lord,
behind the
but
birth in 14.4. By 14,
is there is not
9,
received.
14.10. By 14.10 to 6 months will be over. By 14.10.
Maybe by now, because we sent message on 30th August. 30th August. Now maybe I do not know. Charge sheet has
Because
been
in the
filed.
last order, it was the order was passed on 29th of August,
Yes,
but no date was fixed. That's the matter after 3 weeks was there.
my lord,
That's why it was delayed. I think.
my lord.
But
Maybe by now, more than 1 month have gone. my lord. Maybe charge sheet has been filed. My lord, I may be taken. I will call again one case diary. my lord. In the meantime, instruction may be received.
then can it be fixed after
After,
vacation?
my lord, my lord.
After
my lord,
vacation will
Before vacation, my lord, this is a BA, my lord.
before vacation should
CD may be
call for.
called for.
TV Tariq. 4 is holiday. 4 is open.
4th of October, my lord.
4 we don't want. 310. Okay, it will be fixed on 310.
My lord.
Because the person is behind the
Yes.
person's 14.4. Number 34. And I'm just for 35. The it's just charged case, I think.
Scan copy is there. my lord.
Yes. After vacation. Can I please take it?
May I please, Lordship?
Yes.
37.
Yes, sir.
My lord, the petitioner is behind the bar since 179 days, Lordship. 79 days, Lordship. 179 days. Allegation is under section 366 and 6 of POCSO, Lordship.
Yes.
Well, perhaps notice is not served because no name has been shown. This is earlier date, notice issuance for notice of was issued. Order was passed for issuance of
On
notice.
30/08/2024, one order was there for issuance of notice.
Notice, yes.
There
Step
are
Lucilla.
taken any
Steps,
steps?
Lordship.
Steps you have taken?
We have taken steps, Lordship.
Okay, let's see.
We have taken steps. My lord, 179 days in custody, Lordship. My lord, search sheet was submitted. Thereafter, search was framed, Lordship. Search was framed on 7/8/24 under section 366 IPC and 6 of POCSO, Lordship. My lord, thereafter, they filed bail application before the learned court below, Lordship. That was rejected. Lordship may kindly see order at page 33.
We are seeing bail.
Evidence received.
Evidence one है।
Witness examined one. Search the information.
Sir, 7/8/24.
7/8.
If was taken in fact.
Whether
What
victim is
is
examined.
the name of the
Petitioner Anwar Ali, Lordship.
Anwar, na?
Yes, Lord.
So page is listed before appropriate time. Once it was rejected or allowed, what?
No, not this is rejected by this honorable court, Lordship. It was rejected before the learned court below. Order, Lordship may find at page 33.
Call for the scan code.
Here it is observed that the victim has submitted that she has no objection if the accused is enlarged on bail, Lordship.
That I whether it is served or not.
No, if notice is served and nobody appears, in that case, we can go for legal aid counsel.
See, that extra meter report for ascending.
Steps কি register করতে
দুটা মধ্যে তবু দিয়ে না দুটা মধ্যে
What is well said.
30 আগস্ট তো লিখছি নাকি steps কেটে লিখছি
এই শুনো 30 আগস্ট হয় 30 আগস্ট এদিনাই লোৱা হৈছে
আজি সেটা 20 তারিখে
30 আগস্ট
may I submit one thing, Lord? Perhaps on 30th August, he has taken steps as per order dated 30th August. Now it is 20 days only, my lord. He has within 20 days, my lord, service report is difficult to reach our office.
My learned senior may do one thing. My learned senior may take instruction over telephone that whether the notice is served upon the victim or not. After some time, matter may be taken.
মই কেনেকে ইনস্ট্রাকশন লম তোমাদের মতো আমার তো মিশন লাগে আমার থ্রু দি ললে হে আমরা
আজি পক্ষতো ভিডিঅ কৰি দিলো আজি
It may be because due to some unavailable circumstances. But as per Deepak Nair's matter, most probably today,
One week time may be given now. Because due to some unavoidable circumstances, we are unable to get the instruction from office. There is some, so lordship, 1 week time may be granted. Within that period, we will collect.
What is the stage of the case at present?
Victim yet not examined, Lordship. No witness has been taken.
Victim not yet examined.
Not examined. But he was noticed from the court. She appeared and submitted the page 33, Lordship. May I kindly see?
Before whom?
Before the court, Lordship. Before
The court.
yes, Lordship. As
Recording her evidence.
no, Lordship. As bail application was filed before the learned court below, she was noticed and she appeared. And her opinion has been taken. Lordship, may I kindly see page
Page
33.
33, my lord, next slide.
Page 33. Third para, Lordship. Page 33, third para. Second para. Today, the victim has turned up after receiving the notice in connection with the bail petition number so-and-so, dated so-and-so, filed on behalf of accused number so-and-so. The victim has submitted that she has no objection if the accused is enlarged on bail.
But considering the deputy of the
Yes, yes, not.
because her consent, her application.
Lordship, I am also.
You want 1 week? What? The hard picture.
Am I asking?
Yeah. Hard picture. Am I? Not the hard picture. Different persons, 179.
179 days.
178. And so file and subject that has more okay. But from the office note like from your notice is not on this number as the from subject one with from the better the not can compare together. According to want any date fixed?
The date may be fixed, Lordship. 179 days.
Like government put 110. We're fixing it 110. 1.
Obliged.
Can I bring? Oh.
39 case there is there. No?
May I please, Lord? Well, the FR page 13, ma'am.
By the page 13.
Page 13, yes, ma'am.
Notice service.
Notice report of an
Second in case of POXO.
Also,
is there,
notice
yes,
has to be served. No,
We have
no
not
name
taken
is
any
being
steps also, I think.
Ma'am,
Taken any steps?
Lordship, matter is avoided for
Avoided.
service report.
Avoided.
No, ma'am, it is avoided for service report, ma'am.
Awaited.
Yes, ma'am. Last occasion, 1 week time took by the my lord prosecution side.
Yes. On that, it is still there.
নাই দিও না সিডিও নাই হ্যাঁ Hello, let it be taken up after some time. I instruct take instruction from the office.
Lordship, obliged.
Whether we have restricted
40 case there is not there. Case there is not there. 41 case there is there.
Is
40
that
case there is 40.
My lord,
41 you are appearing for the
I'm
respondent?
appearing for the respondent.
my lord, FIR is case 9, man. My lord, mother lost the FIR, saying that her daughter was missing. When
41.
my lord, she went for outside, my lord, and 9:30 p.m. at night on 9/5/2014, and they charged different place, did not find her. Thereafter, they came to learn that present petitioner kidnapped her, hence the case, my lord. In fact, my lord, the admitted fact, the present petitioner, my lord, he is 19 years old, and the alleged victim is, my lord, 17 years old. And they have, my lord, developed the love affair. Initially, they introduced in Facebook, my lord. Thereafter, my lord, she did not disclose that she is not, my lord, marriageable age. And deep love was, my lord, created between them. She voluntarily came to the house of the present petitioner. And when he searched the document as proof, then found that some days is short, become the 18 years. Then request her, you go, and when we will get the marriageable age, I am also not marriageable age because the boy is 21 years is required. All the parents, and they have come and taken her. Now this is the case, man. In fact, nothing happened. It is admitted fact, well, this must happen.
Yes, that.
My lord, what you can see the 164 statement.
Yes.
Your Lordship, I have not produced the case diary, but the petitioner is pleading that he had a love affair with the victim. Your Lordship, until the interrogation and everything is done, anticipatory bail at least may not be granted. He might influence the victim as well.
So once you have second, what is your submission in fact?
Lordship, I have not seen this case diary.
Case day you are not supposed to see, but
Yes.
otherwise, what is your submission?
Otherwise, there are high chances since the POCSO matter, the accused might influence the victim and might try to threaten her. Accordingly, I leave it to your Lordship.
Now he is saying that your family members have come.
Lordship, I don't have any instruction to that effect because I'm appearing as an amicus curiae. We don't have contact with the victim's family. And since it's a POCSO matter, even if the parties come for a settlement or something, it cannot be taken up in a bail
this is different
proceeding.
thing. Otherwise,
That's a
what is
different
your submission? That's what I'm.
on that particular point, Lordship,
You don't have any
bail cannot be granted. No bail can be granted.
No. Bail can be granted otherwise. You don't have any instructions in fact.
To that effect, I don't have instruction whether the victim's family have approached the accused family or not. But even if there is some settlement talks or any talks going on between the two families, even then, that cannot be considered in the bail proceeding. That will come up if at all there is a joint petition before this honorable court that any settlement has been arrived at or something like that. That is not on record.
Yes, that's any.
My lord,
From your side, I have seen the record.
My lord, admittedly, there was love affair. Now, whether
That is the-
also,
Only 19 years old and she's about to 18 years. About 1 year difference.
FIR says that she was 17 years old.
that- 40, 40, 40, 40. Check. Uh, it, that- it, sub- it, that up. Or that part not what the problem of the another predicted okay, well that's it. And
Bless you.
before the eye with 7 4.
I'm blessed.
Like, just one
Your
submission.
submission is the record.
Doctor, is the name could be recorded.
Yes, yes,
Dr.
I have
P.
already recorded Dr. P. Agarwal.
Dr.
is there, my lord?
40 feet. Unable. Oh, wait. That is that it's the method for
110,
1 week.
1.
Lordship, the petitioner have appeared, Lordship, but up to date CD was called for. Up to date CD is not received, Lordship. He's on interim, Lordship.
Yes, Lordship.
Interim.
Yes, Lordship. Interim is there.
And as per your instruction, they have already appeared.
Yes, Lordship. They have appeared, Lordship. There are two accused persons, Lordship.
One is absconding, Lordship.
One is not absconding. On 3/9/2024, he got absolute pre-arrest bail from this honorable court.
So, সেইটো কাৰণে report call কৰিছে absconding has the last one or two order আছে as per order of the last order of the CD, Lordship, he was not there, Lordship. Now maybe he appeared and got absolute bail for that up to date
So
CD
you
was
are
called
appearing
for.
for one only.
Yes, Lordship. I am appearing for the other accused person, Lordship.
Sunil Kumar.
Sunil Kumar.
Sunil Kumar, Lordship. And Lordship, against Sunil Kumar, there is only one allegation, and that is whether, Lordship, the up to date case
No,
diary
no,
is
it is not there. Last date is of 1/9.
Then, Lordship, let the up to date case diary be called.
Now you got your bail on when? Interim bail? 5/8.
Yes, Lordship.
Then it is up to date. I think 1/9 is there.
1/9 is
His
Lordship.
petitioner's statement is available or not?
It is there, Lordship, in 1/9.
Then where up to date bail got called.
Lordship.
Okay.
To 1/9 only case. 1/9.
I think case diary is up to date, Lordship. It is 1/9.
Oh, 1/9.
And Lordship, our case was not listed, Lordship.
Then
After 1/9, our
it
case
is
was not listed.
up to date, Lordship. Lordship, the parent.
No, you will say whatever.
Lordship,
This petitioner's statement is available. Petitioner's statement is available.
Lordship, let
It is here.
statement record para me लिखिस देता है. तो क्या सुनील कुमार का ऑर्डर हुआ क्या Lordship, he's recorded, Lordship.
You want any time that you have
সুনীল কুমাৰ দাসে মাননীয় আদালতৰ হাইকোৰ্টৰ অৰ্ডাৰ সন্মান জনাই থানাত আহি উপস্থিত হোৱাত তেওঁৰ বৰ্তমান মাননীয় হাইকোৰ্টৰ অৰ্ডাৰ সন্মান জনাই তেওঁ সোধা পোছা হোৱা হৈছে সোধা পোছা
then you peruse the case diary and submit. Have you gone through the have you
No, Lordship, I have not done, Lordship, then I'll have to go through it.
at 2?
At 2, Lordship.
Hello.
Lordship, I'm sorry, Lordship. Item 43, Lordship. I was in court number 2, Lordship.
It is already order has been passed after 1 week.
Right.
No advance order is there.
Nobody appears below.
5 weeks. One and
41. One, I don't know.
it's for 1. You're for 1.
But I'm for opposite party number 2.
Opposite party number.
Also, date may be fixed.
Huh? Date.
What for?
None evidence for part. It has been done. And MS? You are MS?
P for Gary.
It's for get for you want to fix it?
Yep.
2910 after vacation.
Lordship. Okay.
Fair pleasure. Lordship, in terms of the earlier order, Lordship, we have deposited the arrear amount. It is a case under 125, Lordship.
Okay.
So we have deposited the arrear amount in respect of the daughter of the petitioner. Lordship, may keep it after vacation in
Now, as per last order, total amount only on 5/9 we have already deposited 55,000 to the respond number 2 inclusive of area amount of maintenance of 50,000 for the month of July.
Lordship, till July, area amount was 1,25,000. He paid installment wise. So area amount to his minor daughter has been paid.
arrear amount
till
has
July,
been cleared, Lordship.
Till July.
Yes, up to July he had already paid. Now
Now, I have paid in the last occasion that he kindly direct him to continue the
No,
monthly payment to his daughter,
We will
and
continue.
area payment to respondent number 2 is to his wife has not been paid.
No, it is under challenge, Lordship.
it is under calendar.
It is under challenge.
So you continue.
We will
the
continue.
monthly
I will
payment.
continue. So far as daughter is, Lordship, we are agreed to pay.
You have not currently pattern.
Yes.
Part- Where am I?
May A Borwa. Anjali.
It's submitted extra as per the decision. Oh, they had already paid. Yet for she is respond number 2.
No, for the minor daughter,
For the-
Your Honor.
of
For
the-
respondent number 2, it was 7,000 per month. For 5,000
No,
The
no,
daughter of
to minor
respondent number
daughter.
2,
Is the daughter.
Respond number
minor daughter.
Respond number 2.
2.
Respond number 3. For the subject as per the monthly dated for and up to 1 July is monthly payment. So, however, dated effect of the month that first month that what is it after picking in it pay the monthly
Yes,
part
Lordship.
part of the
I'll pay. I'll pay.
Monthly payment for the girl tax regular
Public. May please, Your Lordship.
here
My lord.
Mr. N. Alam has already appeared.
My lord. On the last occasion, my lord, respondent number 2 is strike off as a
Respond number 2, name of the respond number 2 struck off.
strike off. You are the informant, Your Lordship. Respondent 2 is died, my lord.
Respond number 2 that.
My lord, in this case,
Now
there is
who is the respond number 3?
respondent number 3 is the wife of the petitioner, Your Lordship. They are passing their days peacefully, Your Lordship, husband and wife. And out of their wedlock, one female child is also born. School going cycle. So proceeding before the trial court has been challenged in this case, Your Lordship.
So you are agree with the order dated 28/2020
My lord, enter proceeding of the
entire process.
my lord. The petitioner and the wife of the petitioner, that is the respondent number 3, he was the victim of this case, and they are passing conjugal life peacefully, Your Lordship.
At present.
My lord,
At present.
since their marriage, Your Lordship, in the year 2017 they got married.
Then when dispute arose,
My lord, actually, out of the love affairs, my lord, the petitioner and the respondent number 3, that is the victim, point away from their respective houses, and they got married to each other
what is the case
after
about?
completion of 18 years.
What is the case then? Case was registered under which section?
My lord, kidnapping case was registered, your lordship. Apparent page 13, your lordship.
He has to file affidavit, my lord, because this is a charge sheeted case. Charge sheet has already been submitted. So now if they want to, my lord, compromise, they will have to file affidavit, my lord.
Yes, have you filed any written?
I have no objection. Now we have living.
The Bharwell will not do, na? You file an affidavit.
My lord, till then,
And
my interim period may kindly consider, my lord. Let him file
that's
affidavit.
not three. Huh? Khadija Pradhan.
And both the petitioner and the respondent number 3 are also suffering, my lord, due to pendency of this case, your lord. They are passing.
What is your reply?
My lord, this step,
He absconded actually.
Is that content? You don't know anything. You have content.
no, my lord, showing
Yes,
absconder
in the-
charge sheet was
I'm
submitted.
In the charge sheet, my lord, he has been shown as absconder.
My
Huh?
lord. But police did not visit their house.
Take instruction, go to take instruction, let it submit. Only submission that the matter has been compromised with us.
Then we have filed it.
Huh?
Then we have filed it.
You?
We have filed affidavit. Lord.
Yes, you should. You have not done for anything, simply submission that they are staying together. It has already been registered. The 366 as apart from which section? Not only 366. 366A it was it. Subsequent is also etc. also added it. Yes or no?
In fact, after completion of 18 years, they got married, your lord. I have annexed the document also, as proof document also. my lord.
Hard era.
My interim period may kindly consider, your lord.
You are
On the-
absconded.
On the last
Here
occasion,
also cannot be considered.
but
We'll dispose of the matter, entire matter, after, as he has already been stated that matter has already been compromised, but what will be the interim
my
period?
lord, otherwise, warrant will be accepted, my lord.
Five district, yeah. Five district. Submitted by Mr. A for the petitioner, case one number three, that's being read. And to that effect, Mr. Adam was submitted that would petitioner that living together as a but if the petitioner is not joined by accordingly the respondent by the affidavit. They're listing it after before vacation. Okay. Before vacation, before after did go by 110.
Right.
Prior to 110, you file your affidavit. Stating that you don't have any objection, whatever you want.
Well. I'm like,
May I please lordships. This is a 482 petition, my lord, for quashing the my lord proceeding, my lord, is pending before the learned SDGM, my lord, at Borbeta, my lord. So in this case, what happened, my lord, in the year of 2020, my lord, and in this case, my lord, petitioner is the son of the petitioner, that means accused, is the son of the respondent number 2 and 3, my lord. Respondent number 3 is the victim of motor accident, my lord. And respondent number 2 was a pillion rider riding by the vehicle riding by the my lord petitioner, my lord. And thus a motor accident took place, and thereafter respondent number 3 lodged an FIR at Borpeta PS, my lord. And thereafter the case has been registered as, my lord, under section 279 and 338 IPC. And subsequently, my lord, the case has been charge-sheeted and, my lord, now pending SPRC case at Borpeta, my lord. My lord, after registering the case, my lord, what happened in between the, my lord, all our family members, my lord, because, my lord, accident matter, my lord, motor accident matter, they have amicably settled the matter and requested the officer in charge of Borpeta PS, my lord, not to proceed further, and thus they wanted to withdraw the case, my lord. But as the case has been registered, my lord, and thereafter charge sheet submitted, declining the prayer of the petitioner as well as the respondent number 2 and 3, my lord. And now, my lord, thereafter, only on the basis of amicable settlement, my lord, we have approached before this honorable court to, yes, my lord. In this regard, my lord, so many judgments and orders passed by this honorable court, my lord. I would like to place all the judgments. It will work. My lord, recently I have placed, my lord, one in criminal petition number 992/23, my lord, and similar nature case, my lord. This honorable court has passed the, my lord, judgment whereby, my lord, was the proceeding, my lord, and of a PRC case that was pending before the judicial magistrate first class at Boko, my lord. And the case was registered under section, my lord, 279 and 304A, my lord. Like nature case, my lord. And that is, my lord, in 992/23, my lord. Another case, my lord, that was disposed of by this honorable court in, that is, my lord, Ali Muddin 596/2019. That case has also been disposed of by quashing the proceeding before the learned CGM, my lord, Kamrup Metro. In both the cases, my lord, and thereafter, my lord, one case, my lord, that is reported case, my lord, State of Madhya Pradesh versus Lakshmi Narayan and others, my lord. So I have placed, my lord. As per, my lord, guidelines, my lord, for the ends of justice and to avoid the, to prevent the abuse of the process of court, my lord. As this honorable court have ample power, my lord, to quash the proceeding, as the matter has been amicably settled, and it will not affect the social demography, my lord. It will not affect any, my lord. There is a, to some extent, my lord, private nature's case, my lord. And in some cases, my lord, that those cases may not be quashed, which are heinous in nature, my lord.
I have
Yes,
no
sir.
objection, my lord, if the matter has been quashed. my lord.
You are being for 20.
Yes, my lord.
It's already they filed, my lord. I have received the copy, my lord. They have filed, my lord.
Supreme Court is a accident claim or case.
No, no, my lord. Just other cases, my lord. I have
My
placed,
lord, I have come across
in
accident case. The apex court has taken into account the galloping rate of, my lord, accidents in India, in the country. And it is not correct to say, as has been submitted by my learned friend, that this is not against society. But the entire economy is involved. In tomorrow, insurance will be claimed by the victims. Then, my lord, deaths are being occurred due to rash and negligent driving, my lord.
Yeah.
So that cannot be equated with this stuff. Gyan Singh or other Lakshmi Narayan's case will not come, my lord. States insurance, that is why, my lord, stringent laws are being made, my lord. Helmet, wearing helmet, my lord, all these things are there, my lord. So, and, my lord, in one, I have come across one case, in this type of cases, my lord, your lordships know, due to rash and negligent driving, only 3 months or 4 months punishment is given. Well, even the apex court has said that well, in rash and negligent cases, the provision of Offenders Act is not applicable. So this is the position of law. My lord.
Yes.
This cannot be compromised like
Yes,
this.
my lord is rightly, my lord, submitting my learned friend, my lord. But what
This is
happened in
not
this case?
purely private
To
matter.
my lord, that what will happen, my lord, if the proceeding will continue? Then, my lord, their stand is that they would like to withdraw the matter, my lord. Then it will be mere the abuse of the process of law, my lord, and it will happen nothing, my lord. Result will be, my lord, zero, my lord. That's why, my lord, if the matter relates to, my lord, some heinous matter, my lord, that cannot be quashed, 302, 376, etc., etc. But, my lord, this honorable court has had already, my lord, passed several judgment. I have placed, my lord, a similar nature case, my lord. In the, my lord, in the case, my lord, I have already placed before your lordships, is clearly stated, my lord, in in, my lord, 992/23, my lord, in para 8, my lord. Yes.
And the was the but at of the food that and put that with but which by good that I fear that to the people that that among them but I fight and and my one for what of had further further the death of the book of case of the final of the cases from voter are like like this the that the good and the good and profit but bad that but bad but bad that compromise and not that much against their son MS M without not the error the true of technology not the fit for what now by guidance for the again that the that cannot be considered as the office of admin. And the correct text now considered as the crime. Uh, that that obviously that got the document cannot be so ground for voting. That that has both big as that of it. So both are that appear both as presented that it had both okay, your bit that's allowed. It's allowed.
Obliged, ma'am. Much obliged.
Obliged, my lord.
Lordship, respondent herein filed a complaint petition under section 145 CRPC in the court of learned magistrate Kachade Silchar
125.
145 and 146.
Petition under 125.
145, Lordship.
145.
45.
Oh, that's what. Anyway, it's against 145 proceed.
Lordship.
Okay.
On receipt of the notice, petitioner and respondent, that is present petitioner entered their appearance, they filed their WS, and thereafter they abandoned the proceeding. Case was proceeded ex parte. Learned magistrate passed the order after hearing the first party, that is complainant side. Lordship, and possession was declared in favor of the first party without police report, and also first party also did not examine any of the neighbor of the place of occurrence. Police report also not called for, and the learned magistrate declared the possession in favor of the
Where is the order?
Lordship. Impugned order, Lordship, kindly have a look at page 19, Annexure 3. And against that order, Lordship, petitioner also preferred a revision petition that is also dismissed. Page 19, Annexure 3.
So, no, this is the order. Page 19 is the order.
Order. And Lordship, order passed by the revisional court, Lordship, that is at page 26 to 30. Lord.
So, against that order, you have approached for divisional court for review.
Lord. Lordship, kindly come to page 30, para 8, finding of the learned revisional.
Page?
Page 30, 30, para 8.
Yes.
May I read? Learned magistrate expressed his satisfaction on the basis of his evidence of 4 PWs. Though there is no police report with regard to arrive at the conclusion about the breach of public peace and tranquility, however, the evidence adduced by the PW1 is sufficient enough to arrive at such a decision. The court below correctly discussed the evidence and rightly arrived at the conclusion. It is therefore I do not consider to interfere with the finding of the court below. It is to be noted that the possession that was declared in favor of the first party is a temporary measure to contain the disturbances of peace and tranquility only, and not for other purposes. So, to decide this issue, peace and tranquility, and also Lordship regarding the possession, police report was very much necessary, but that was not called for. And also, Lord, one core witness examined by the first party, none of the witnesses are neither of the place of occurrence. So, such a finding is totally Lordship perverse. And they filed their WS. In the WS, they categorically denied. Lordship, kindly have a look at the WS filed by the present petitioner before the learned magistrate. Annexure 2, page 16.
Connected to page 16.
Lordship,
This is
annexure to
WS.
WS. And in the WS, Lordship, kindly have come to next page, page 17. The main fact of the case are as follows. Magic, Lordship.
You
That
also
the
claim your position here.
according to the petitioner, we are petitioner is in we are in possession, but after declaring possession in favor of the Lordship first party, there is some change. Lordship. Initially, it was in my possession. Subsequently, it was attached, and thereafter, possession was declared in favor of the first party. So, my lord, my humble submission matter may be remanded back to the learned court below to allow to take the fresh evidence, and the police report may be called for, may call by the learned court below, and after petitioner side also may be allowed to adduce evidence that will no way suffered by any of the parties. Lordship. That
That even if at this present stage, suppose police report is called for,
no,
then only police will not found to
no, not but that will at the relevant time which of the party was in possession, that will be established. That is the law. Lordship. At the relevant time, which of the party was in possession?
May it please the lordship, madam. My learned friend is very cleverly avoided to read out the impugned judgment passed by the learned magistrate, my lord, which I am required to place before your lordship. Page annexure 3, my lord, most probably page 19.
Yes.
Your lordship can see the order passed by the executive magistrate. CR put up today, the first party present along with engaged counsel. Second party absent without taking any steps. Peruse the entire case record. Second party is continuously absent in several days. The case of the first party is that the predecessors of the first party, Sri Ram Singh Dubey, initiated the instant proceeding under section 145 CRPC against the second party, stating inter alia that he is the owner of the proceeding land by your purchase by registered sale deed so and so dated 22/6/2005 from Hajira Bibi and others by the registered sale deed number so and so dated 19/5/2023 from Naziruddin and others, and has been possessing the same within the specific boundary, and that the second party started creating disturbance in the peaceful possession of the first party over the proceeding land and tried to dispose of the first party forcibly, and there arose serious apprehension of breach of peace, of public peace and tranquility in the locality, and as such the first party approached before this court and initiated the initiate proceeding and prayed for declaring his possession over the proceeding land. Hence, the proceeding was initiated. The second party made my lord, your lordship can see, the second party made their appearance in the case and submitted written statement denying the contention of the first party made in the complaint petition. Initially, the proceeding land was attached under section 145, 146, 1 CRPC, but subsequently the same was withdrawn, and at present there is no attachment over the proceeding land. My lord, your lordship, it transpires from the record that the first party, after filing the written statement, is very much casual in their appearance in the case. It is revealed that the second party continuously remain absent in the case, and this court by order dated 2/2/2012 fixed the case for ex parte evidence of the first party, considering the prolonged absence of the second party. But even after this case, the case, in the interest of justice, issued notice to the second party for their appearance in the case, but the second party did not turn up, and by the order dated so and so, this court issued further notice to the second party for appearance. It transpires from the record that the issuance of such notice, the second party made his appearance on the 2 or 3 occasions, your lordship kindly see, in the case, and then remain absent without giving due honor to the honorable court. During the pendency of the case, the first party said Ram Singh Dubey died, and his legal heirs, that is his wife so and so and son so and so, were implicated in the present case on 21/2020 at the first party by order dated 5/9/2020 for their appearance. But the second party did not turn up, and as per the order of this court, the first party adduced ex parte evidence of PW 1, 2, 3, and 4. PW, then my lord, as many as 4 PWs were examined, and as because the second party did not turn up, they were not cross-examined. Then the honorable court was pleased, after considering the evidence of the party concerned, passed the judgment declaring the possession of the first party and attachment. Then against it, my lord, they filed that your lordship kindly see the second party. There are a number of second parties in the case, and the revision before the second learned session judge was filed by only one person. Only one person before the session judge, my lord. Raising the grounds of the revision was that for the learned ADM Kachar Sri W. Wide Vathakur art in law as well as in fact while passing the impugn order. For that the learned ADM Kachar Sri so ought to have ascertained the status of the disputed before passing the impugn order, and as said the wrong was done in passing the impugn order. For that the learned ADM Sri so ought to have heard the parties before passing the impugn order. These are the grounds they took, my lord. For that the learned additional ADM Kachar Sri so ought to have given trace upon the documents filed in petitioner at the time of submitting their written statement. They are submitting their documents in the case without appearing in the case, without cross-examining the other side, or even without adducing evidence, just insisting that the learned session get it corrected by diverting the matter to the executive magistrate. Then for that the learned ADM Kachar Silchar so ought to have considered the facts of the opposite part of OFI have filed some false documents, false and collusive documents for his wrongful death. Then they ought to have appeared and then clarify the matter by cross-examining the PWs, or even they did not do so, my lord. Then they filed the revision. Then the learned session judge, considering the entire matters and the background of the matter, they having failed to appear, adduced evidence, even cross-examination, even cross-examining the PWs, the learned court was satisfied that the order passed by the executive magistrate was justified, and so the revision was dismissed. Now again the two orders, my lord, have come stripping the inherent power of the Honorable High Court. So actually speaking, my lords, is the second revision, which is not maintainable as per law. But just to avoid the system, they have adopted section 482. 400. So in case of 482, sir, there is various judgment of the affairs code, my lord. I beg to place before the law two judgments where the interference of the Honorable Higher Court is very
I'll take a break for just 5 minutes. Take a bit.
much. Of grievance of the aggrieved party, that it could be exercised very sparingly to prevent abuse of the process of the court or otherwise to secure the ends of justice. That it should not be exercised as against the express bar of law in graft, other provisions of the court. They could have, my lord, if he has any grievance or he is not satisfied, the alternative remedy of other court is he go to civil court or raising his dispute. He is claiming his right. Yes, he has his right. His land is there, and we have got our land. We want our land. He cannot disturb us. If he wants to hold over our land, he is to establish it by revealing the civil court, not by way of filing this petition after petition by unnecessary inherent jurisdiction. Then your lordship kindly see paragraph 8. Paragraph 8, my lord. The inherent power is to be used only in cases where there is an abuse of the process of the court or where the interference is absolutely necessary for securing the ends of justice. The inherent power must be exercised very sparingly, as cases which require interference would be few and far between. The most common case for the inherent jurisdiction is generally exercised is where criminal proceedings are required to be quashed because they are initiated illegally, vexatiously, and without jurisdiction. Here, the criminal proceeding as initiated by our side was genuine. He has his right. He purchased. He examined all documents. He adduced the sale deeds. He adduced the evidence of the who proved that yes, he has purchased the land. They got settlement. I have also adduced my revenue receipt. All these are but they did not divert any of these things while visiting the court. Now they have availed the inherent jurisdiction of this honorable court. Then another judgment also, my lord, I beg to place before the losses in my lord. This is 2008 SPC. Here in this case, I beg to read out paragraph 33, 34, and 36, my lord. Paragraph 33, your lordship can see. Your lordship, my paper. The parties have exchanged their counter affidavits and rejoined. Indisputably, there is no quarrel with the well-settled principle of law that while exercising powers under Section 482 CRPC, the High Court does not function as a court of appeal or revision. Inherent jurisdiction under this section, though, has to be exercised sparingly, carefully, and with caution, and only when such exercise is justified by the test, especially laid down in section itself. It is to be exercised ex divinio justitia to do real and substantial justice for the administration of which court exists. When complaint is thought to be quashed, it is permissible to look into the materials to assess what complaint has alleged and whether any offense is made out, or even if the allegations are accepted and so and so. In 34, my lord, paragraph 34, it is so provided. In KP Kapoor versus State of Punjab, these court summarize some categories of cases in which inherent power can and should be exercised to quash a proceeding. Where it manifestly appears that there is illegal bar against the institution or continuance, that is want of sanction. Where the allegations in the first information report are completely taken at their face value and accepted in their entirety, do not constitute the offense alleged. Or the allegations constitute an offense, but there is no legal evidence adduced or even evidence adduced carelessly or manifestly fails to prove the charge. Then paragraph 35, my lord, is so Uh, 36, my lord, I just told you. We reiterate and emphasize that the powers possessed by the High Court under Section 482 are very wide and very plenitude of the power requires great caution in exercise. Court must be careful to see that its decision in exercise of this power is based on sound principles. The inherent power should not be exercised to stifle the legitimate prosecution. The High Court, being the highest court of the state, should normally refrain from giving a prima facie decision in a case where the entered facts are incomplete and lazy, more so when the evidence has not been collected or produced before the court and the issues involved, whether factual or legal, are of the magnitude and cannot be seen in their true perspective without sufficient material. Of course, no hard and fast rule can be laid down in regard to assess in which the High Court will exercise its jurisdiction for quashing a proceeding at any stage. So and so, my lord. Paragraph 13 also may kindly be seen, my lord. So my respectful submission, my lord, they without evidence, they without appearing before the court, just please insisting, my learned very interestingly insisted, it was the duty of the court see there to read out the written statement he submitted. The learned magistrate very well considered his written statement, but they failed to appear, they failed to adduce any document, even failed to cross-examine, and now he has come under 482 before your lordship. This ought to have been in the disguise of a second division. Because skillfully, very tactfully, he adopted 482, my lord, taking the inherent jurisdiction. So I have read out before your lordship. Your lordship has to consider the matter very sparingly. So I leave it before your lordship's consideration. The poor person who has purchased the land, who has got his settlement, who has paying the land revenue, is lawfully approved, the court considered and decided the matter.
In reply to my learned friend's lordship, there is expressly no bar with regard to the maintainability, and lordship, I will submit to judgment. Lordship, at this stage, I failed to bring the citation, lordship. Later on, I will submit.
Pass the order.
Lordship,
if you want to pass, can you submit anything? Submit by
Bar may not be bar, my lord. Without approaching the court below the
lordship, so far other part of my learned friend's submission, I am not at the very beginning of my submission, lordship, I have stated that case was proceeded ex parte. I am not challenging that aspect. Here, my first contention is that whether police report was called for, whether any of the neighbor of the place of occurrence was lordship examined by the first party before the learned trial court. Only on these 2 points, I am submitting before. At the very outset, I have stated that they were all along absent after furnishing their submitting their WS. So, lordship, I am not saying that court do this or that as my learned friend stated. But police report is required. Lordship, may I Lordship kindly have a look at 145 of the provisions of one.
Okay, I'll
Lordship.
read.
It is very clear, either police report or on other information.
Also, other information is denied. He is not admitted, and in his WS he denied. Their part, if it is denied, their part is denied, then it is only police report. They stated that it is there is some breach of public peace and tranquility. Other information from their part that was denied by him. So it is now it is police report by which actual state of affairs would come out. That was not done by the learned court. Only on the basis of his statement that was controverted by him by filing WS, that was not considered by the learned court below. This is my submission. Lordship, Lordship, I submit judgment tomorrow, Lordship. If your Lordship allow. Lordship, oblige.
Tomorrow,
No, only I submit for judgment cited.
it is after your losses. But in the open court, then I could have get the opportunity.
But he can also receive if it is a citation. What Lordship, may I also can cite it this.
Without appearing before the court below at all, my lord. My learned friend is insisting on this. It is up to your losses, my lord.
Lordship.
My lord.
Lordship.
Let it remain as spotted, my lord.
Lordship.
Oblige.
Oblige.
Other side. On item 14.
Worship,
One.
Worship, this petition is filed against an order passed by the Learned CJM.
CJM.
Against an order passed by the Learned CJM in Dima Hassan. Worship, on the last occasion, Lordship, an interim relief has been provided and the scanned copies of the case records have been called for.
LCR has not been received by this court, Lordship, first thing. And notice has been issued in this case, Lordship. I have contacted with my department, Lordship. We are going to file an objection to their petition. Lordship, may kindly fix it any another case, Lordship.
No. For the respondent side,
I am
only. No, yes, you are there. So what about the notice? What do you think? Something regarding
Notice has been issued. CBI is a party to it, Lordship.
Yes, CBI is a party.
Pursuant to the direction of this honorable court, CBI conducted an investigation of the case, Lordship.
So CBI is a party.
CBI is a party. Now the petitioner is the colonel. So as PSG has been appearing in the case on behalf of the petitioner, Lordship.
No.
Charge sheet has been submitted and Lordship, the case has been submitted, I mean to say pending before the learned CCR. Cognizance has been taken. They are challenging that order of cognizance and appearance.
So now you're going to submit your objection. What about the state? State is also going to submit
appearance.
State would be a formal party because initially the investigation was done by the state, but thereafter it has been taken over by the CBI and the CBI has filed the charge.
And the LCR is not yet received.
Not received.
Okay.
There's a flag mark. Lordship.
No, no, Lordship. I'm on Wakalat now.
Also heard Mr. After they modified their affidavit.
Within a day or two.
But the same copy of this note that the cat copy of it was not to so but it can be listed.
Let it be immediately on the reopening, Lordship.
Immediately on the reopening. Yes, and
My instruction is to list as soon as possible. Lordship. Before
vacation.
Lordship, I have got some difficulty, Lordship. I may not be here. That is why I'm making up. Let it be immediate on 21st.
Your reopening day is on 21st. Did the date be fixed on 21st?
21st, Lordship, already fixed matters are there. Lordship. Let me verify.
Oh.
'23.
Let it be on 23rd.
23rd?
That's fine, Lordship.
Okay. So you file your objection within
Yes, in the
that
meantime-
the matter can be heard on 20.
Within a day or two, we are going to file.
Sure.
Lordship,
And we are also calling the can copy of the case
And
diary.
they are already being called for.
Oh,
May I pray, Lordship, the interim order may continue till the next
interim
day.
was there, na?
Lordship,
Yes,
there is no interim. Actually, it was still date.
Still
It was
date?
still date, Lordship.
That is,
There's no
that has to be
interim.
extended, Lordship.
And that I have objection that on that, Lordship, because on the last occasion, as because the case in the trial court was fixed immediately on the date when the matter was heard by this honorable court. So it was heard by this honorable court on 31st of August.
In any case, Lordship, the matter in the trial court is on 5/11.
5/11.
It's
So
on 5/11.
Then
No
not
difference.
affected. It will not affect.
But Lordship,
And
may
if they
kindly-
will extend, you want to extend it.
Yes, Lordship. It may be on
It
record.
can be
Lordship, my objection may be recorded.
Mr. Akin Chaudhary that constitution for the big interim order granted on 31st 31st of August and 31/08/2024. However, Mr. Alpha submitted that your objection basically why?
On stay, Lordship. Because there is
On
no-
stay?
Lordship.
Money you raised objection. Okay, there is objection.
Because today the date was fixed for objection hearing on the stay. Lordship, may kindly have a look into the order.
Yes, well,
Lordship, may kindly see paragraph 3, Lordship. I am learned counsel for the CBI strongly objects to the press made. It is submitted that says prima facie it appears that the interim order was passed by the Court of Chief Judicial Magistrate by taking into account the attending facts and circumstances, and it is violative of any provision of act. He therefore submits that court may issue notice at the stage permitting him to complete his instruction and file necessary option if so advised in the meantime. Accordingly, let notice be issued returnable within 3 weeks. So ensure landed counsel appearing with the respondent notice the waive, however extra copies to ensure. Heard also on the prayer of stay. Issue notice on the prayer for stay returnable on 20. So that was the position.
If he says that he wants to argue without filing an objection,
No, not that. Therefore, I'm praying before this honorable court to fix it as soon as possible. But
let
my
it be on
knowledge-
21st, Lordship. I genuinely have some problem.
I understand he has got some problem on that. Therefore, my only request is that my
23rd, we
objection
are
will
fixing it on 23rd.
Yes, yes.
Only my
And
objection
if
may
you,
be
if he
recorded.
files his reply, Lordship,
Probably how
Lordship can finally dispose it of.
ভালোই ঠিক understanding of regards to stay of the order passed by the court on 3108. The interim order began fulfilling. This is the matter on 23rd. 23rd of October.
And in any case, he is not going to be affected because it is on 511.
I understand, Lordship, but orders they should be produced by the authority. So I always have to object, Lordship. My
Yes, too. So it is very clear that 511 and 23rd
That
of
does not
October-
carry any meaning.
even stay order is there, then also he will not get affected. But I'll get affected if I didn't object.
He's so frank.
May I please, in this case, my lord, steps was taken on 27/8/24, my lord. Can you peruse the office constitution?
Service is still awaited.
Awaited, my lord.
It's a sole respondent.
Sole respondent,
State is not there, na?
not there.
Item number 12, Article M. Rahman, Dedan and Constitution. As per office note dated 8/9/2020, service is still awaited for its full performance. This is the nature. It's after vacation.
After vacation.
It's on the date 15 by the page. This is the record. Shall we see?
Lordship, my senior will be appearing through VC, Lordship.
What I we are sending it.
Lordship.
Just 5 minutes.
Lordship.
Yes.
Please, your lordship. Lordship, this is an appeal against the judgment and order passed by learned my lord Session Judge Majuli, in whose case accused appellant was convicted under section 326. Only 3 years punishment. Already my lord NCR has received my lord.
But what about the respondents? The
To the registry directed to take steps. Respondent number 2, my lord. Yes, punishment. No, section 326, my lord. 326.
The 326, madam.
326. And punishment is only 3 years, my lord.
Else is there, let the matter be fixed for hearing, Lord. Paperbook banabo.
But the question is that they have made a party, na? That's the problem.
My lord,
Party, if party would not have been there, then it's okay. But now the party is there, na?
Then let the notice be returned.
Have you sent? Have
my
you
lord,
taken steps? Any steps for?
order was there, my lord. No, order, my lord, order was there that the registry was directed to take steps for respondent number 2.
Acha, as because
Order
it
is
jail appeal.
there, my lord.
Okay.
As it is a legal service matter, my lord.
Okay.
Jail.
Jail matter.
Paperbook banabo লাগিব তেতিয়াহ'লে আপুনি পোৱা নাই। Registry may direct for paperbook also, Lord.
Paper book will be required.
Paperbook not received, my lord. Short date.
RMS PB board of Learned. You are legal aid counsel.
My lord.
Legal aid counsel. Learned legal aid counsel. Not hard and PB. HY has already raised that PPT paper the matter record for but in ETL after after okay, it will be listed as a hearing column after 3B
My lord.
and raised is directed to preparative paper book as LCA has already been.
My lord. Highly obliged.
I said go back. Yes, 16.
Your Honor, the report from the judicial district magistrate has not been come yet, Your Lordship. So kindly issue a press reminder, Your Lordship.
LCA for LCA not received. Or LCA not received. Earlier it was there. Report regarding Gimmani.
Watching of it.
It's a case of 376. There is a report that addressee cannot be located. So do you have any proper address?
Informant of
Recent, proper, or present address?
Basel address. You are a mother?
No,
Private. 16. মানে sorry point report you have given notice to raise the report.
Did he take this letter? No, I don't know. I go to
Using notice in how
Answer to take steps to jurisdictional police station otherwise.
that is only better. That will be better.
But in this case, are the PP office will be required or in that case also? No, but it's 376.
For jurisdiction
police station.
Only 376.
You are MS?
And Kolita.
Hard MS. Also hard. From the office note, it is seen that the steps on the service report of the on the respond number 2 not yet returned. Accordingly, and it is reported that the address of it is reported that the address cannot be located in RTL. According to petitioner side is hereby that take press case on the respondent number 2 through jurisdiction. LCR has received? No.
No, Lordship.
Can copy of the LCR may also be called for. Take the case of charted one or not yet charted. Case is charted.
For I think not solicited, Lordship. Copy of the bail order,
Not that.
not solicited. 8-9. Bail order was of 8-9, Lordship. 2023. Solicited is in it. I don't know, Lordship. It is not protected in the petition copy. Passing. Not solicited. Passing of the petition.
Not solicited.
Not not solicited. Nothing. Passing of apparent.
Yeah, here now there is no order for calling any case diary or record.
No, Lord.
So you want that should be
LCR. No,
LCR?
let the
No, not LCR, but the CD.
Lordship, earlier it was very on bail, Lordship. The last date was Lordship 8/7/2000, order of 8/9/2023. Shall appear before the IO, and when call for then interim was
But
there.
the question is, this is a criminal petition for quashing the
Question
FIR.
of the FIR.
So you need the, I think it will be, CD will be required.
CD will be required, Lordship. CD will
But
not be
after her appearance, like
Lordship. The information
is the matter according after. You take steps on the respondent number 2, that is the victim, through jurisdictional police, because otherwise it could not be located at. It will be listed after it.
After 2 weeks.
Am I audible, my lord?
Yes, you are audible. Yes. We are taking on item 17, thereafter we'll take your matter.
Obliged, my lord.
May I please, your lordship, service has been completed.
Service is already completed.
Yes, lordship, we have filed the affidavit. Affidavit is in record, lordship. Lordship, as per the earlier order, there is an observation that the interim may be considered after completion of the service, lordship.
Yes. Thus, was there any order for interim prayer?
Basically, this is NIR case. We are formal party. my lord.
Formal part. A respondent not yet appeared.
Yes, lordship.
Notice service.
But here the,
In that
the
case, your lordship
necessary-
may proceed with the matter, my lord, if he is not interested. my lord.
maybe, but
Admit Hussain. Admit Hussain. Admit Hussain. Perhaps it is not admitted yet, my lord. If it is not admitted, then let it come up for admission in the next week or after vacation.
Lordship may consider the stay, lordship, till next day.
since it's the case of 138, in fact, that's why
Yes,
the
lordship.
party is the opposite, the respondent, the necessary party. Here you stay. We are on 17. You are MSP Bora?
KM Sekya, lordship. KM Sekya.
RMS KM Sekya. It's submitted by her that the notice has already been served on number that contact. They have already filed their additional affidavit. However, no one has represented the respondent number 2. Hearing only. What is the stage of the case at present?
Now the cross examination is will be started on 28/10 The next date has been fixed.
28/10.
Lordship.
Okay, we are fixing it then 21/10.
Lordship.
For admission.
For 21/10 for it. Because the LCR has already been received. In
Yes,
time.
Lordship.
So matter may it can koi dok apni it koi dok that point apna it to dikholia here 18 yes.
May please, Your Lordship. In this case, service to the respondent number 2 is not completed, my lord. But in respect of service, completion of service to the respondent number 2, there is some difficulties, my lord. This case was registered under Child Marriage Prohibition Act as well as Reduced Section 6 of POCSO Act, my lord. At that time, so many cases was registered where this informant is not belongs to the victim family as well as known by the victim family. This case is also same. This informant not belongs to the victim family, not known by the victim family, my lord. Thereby, the informant one Rahman Ali address was located by my lord Helipad T9 Nagar, house number 33, Bohisto. Probably that address was a rental address, I think. And I have taken a step on 24/6/24. Not properly served to the respondent number 2. My humble submission before this honorable court, my lord. In this case, informant is not belong to the victim family, not known by the victim family, whether required or not to the service to the respondent number 2. Is it required, my lord?
It's also registered under POCSO Act.
POCSO Act, my lord. And
Then to we
victim
don't
girl herself is the petitioner in this case, my lord. And my lord, page 32, can it be for a moment, my lord? Page 32, 164 statement of the victim girl. May I read, my lord?
Given page
32.
A statement before whom?
164 statement.
How you have received this one?
It was charge sheet. Trial is going on. This case is evidence stage, my lord. Copy served to the accused.
Copy was already served?
Yes, copy served. And
I don't know, but if one formality is there, then
there is a difficulties, my lord. And victim girl herself says that on the day of marriage she was major, not minor. Before the magistrate, she is stated, my lord. So in these cases not fall under section 6 of POCSO Act, my lord. But at the time,
step under which process?
my lord.
Registered AD only.
Yes,
You
registered
have
AD.
taken steps to registered AD.
Registered AD, my lord.
Yes, that can be jurisdiction police station.
Yes.
It may serve your purpose, or if not, then definitely matter may be heard. Otherwise, I don't know.
Is it required, my lord? Informant is not belongs to the victim.
Her statement, I don't know, because he is a minor, considered to be minor.
Yes, the case is minor, but
Why
in
is
fact,
it under 6 of the POCSO?
the allegation is that, my lord.
Charge is framed under.
Yes, charge frame.
Charge is
Under
so
section?
framed.
Under section, my lord, 6, POCSO is there in the charge.
POCSO will be there.
And we have submitted discharge petition before the Rana trial court. That was rejected. That was I have made impugn order in this case.
Page.
Impugn order page 22. And copy of the impugn order dated 25 charge set 27 to 27. Page 27. It's a long order. 28.
Believe. Your mobile.
Sorry,
phone
page
will
30, page
custody.
30. Page 30. Charge set. Section 6 POCSO Act.
6 and 6.
Section 9 PCM.
Let him take steps through my office, Lord. I try to manage.
I am paying for interim protection, my lord. There is a victim girl herself.
Such kind of thing, how can it be in
Victim girl herself stated before the court she is major. And here is petitioner number 2 is the victim girl herself, my lord. And now they are continuing their conjugal life as a husband and wife.
That is true. You Mr. A.K. Azad?
A.K. Azad, ma'am.
Heard Mr. A.K. Azad, that of the petition. And also heard Mr. Dida Zidane. From the office note dated 17/9/2020, in that service on respondent number 6 is submitted. Wait, that on Mr. Dutt, that the notice may be served through the office of the according to the petition hereby that is expressed on the response through through judicial to the office of the public prosecutor. This is the matter accordingly. After vacation or you want anything? After vacation?
After vacation, my lord. But date may be fixed, my lord. Date may be fixed, my lord, after vacation.
Date cannot be fixed.
29th of October.
Because by that time our office will also be closed, my lord.
29th of July.
They did come after 4 weeks, my lord.
Then after 4 days, my lord.
What is the stage of the case at present?
Now evidence is this, my lord.
It's a material.
Most probably.
May I please your lordship?
Yes.
My lord, I won't take much time in this matter. The matter is relating to a sessions case where a section under 120B, 302, 326, 325, and 341 has been made alleged against me. The petitioners before your lordship has come before this honorable court in light of the law laid down by the honorable apex court in the criminal trial guidelines. What is the main issue is that when you file a charge sheet under 173, earlier the CRPC, old CRPC, that at that point of filing of the charge sheet, the the concerned court has to ask from the IO that the list of documents, list of material things which they have carried out in the investigation, but they are not relying upon. So you have to give that list to the court so that in future, the defense can use that documents for their defense. What happened? The reason behind is that there are certain documents which can cause the case at the initial stage. Prosecution, there is a certain thing that they try to withhold those documents. Accordingly, the Honorable Apex Court, by judgment dated 2021 10 SCC 598, the judgment was passed. And accordingly, all the high courts, including our high court, has made an amendment to the criminal rules by exercising the power under Article 227. And according to the high court guidelines also, it is mandatory on the part of the magistrate and on the part of the IO to comply with the guidelines. That is, these are the documents which I am relying in the charge sheet, which will be forwarded to me under 207. And these are the documents and material things which I have collected in my investigation, but I'm not relying, but I'm giving it to the accused. That is the essence. Now, in this matter, what happened? That proceeding has not been, that aspect has not been dealt with. Accordingly, this honorable court, by order dated by order dated 15 February 2024. 15 February 2024. My lord, may I kindly come to the order. 15 February 2024.
Yes. Which page? Page number.
No, that is no, that will be an order sheet. Order sheet, my lord.
Order of
in
this.
our
Order sheet. Yes, yes, my lord. Yes.
15-2.
15-2, Lordship.
15-2.
Yes.
Yes. Heard Mr. S. Borgo, learned counsel for the petitioners. Also heard Mr. P. Botaku, learned edition PP appearing for the state respondents. Scanned copies of the LCR has not been received. Listed matter again on 23rd April 2024. Till then, the learned trial court shall not pass any adverse orders against the present petitioners. The scope of this order was, what happened? Already the charges have been framed against the accused persons. And the prosecution evidence has commenced. Since my issue was pending before this court, I appraised this honorable court. The honorable court said that, okay, no adverse order will be passed because I am not examining the witness till now. Because since if these orders are set aside, the entire exercise will be futile. Entire exercise will be futile. And it is a procedural aspect. It is a procedural aspect. So, my lord, my colleague will furnish a copy of the judgment passed by the Honorable Apex Court recently regarding a law laid down that if a particular person is arrested, is in custody in connection with a particular matter, can he apply for anticipatory bail in regarding to another case where this Honorable Apex Court held, it is Dhanraj Ashwini versus Amar Mulchandin. The judgment is there. Kindly come to para 62. Kindly come to para 62. Para 62. I'm reading it, my lord. Similarly, a constitution bench of this court in state of West Bengal versus Anwar Ali Sarkar reported in 1952 1 SCC 1 held that procedural law confers very valuable rights on a person and their protection must be as much the object of a court's solicitude as those conferred under the substantive law. Few pertinent observations are extracted herein below. Quote, the argument that changes in procedural law are not material and cannot be said to deny equality before the law or the equal protection of the laws, so long as the substantive law remains unchanged, or that only the fundamental rights conferred to in Articles 20 to 22 should be safeguarded, is on the face of it unsound. The right to equality postulated by Article 14 is a fundamental right as any other fundamental right dealt with in Part 3 of the Constitution. Procedural law may and does confer very valuable rights on a person, and their protection must be as much the object of a court's solicitude as those conferred under substantive law. The reason behind, my lord, the reason behind the law, I'm being from my side to indulge this honorable court on the ratio of this recent judgment, is that it's very limited in the scope, but it has got a far-reaching impact in all the criminal trials in the state of Assam. It is not only in this case which we are observing, my lord, because when the Honorable Apex Court lays down a particular law, it becomes a law by virtue of Article 141. And if my lord may see the Constitution, Article 142, it says that all the authorities must act and aid and advise, must act to give effect to the law. That includes the judiciary. Now what happened? The Supreme Court has said that in criminal trial guidelines that you must do in this particular manner so that in the future the benefit can be taken. And accordingly, the High Court has made the rules changes. Now, in spite of that, if the lower judiciary contemplates or acts in a manner which is totally against the settled position, it gives serious connotations infringing Article 14. Now, I'm relying to the order passed by the trial court of 3rd August 2024. And on that order, Mr. Chakma, can you please forward the order? 3rd August 2024. Kindly come to the first page, last para. First page, last para. Bottom para.
Yes.
The Honorable High Court has not stayed proceeding of this case, but the order dated 15 February 2024 passed by the Honorable High Court directed this court not to pass any adverse order against the petitioners. The case is pending for cross-examination of PW1 and PW2 since 4 August 2023. Trial has not proceeded since then, as the learned counsel for the revision is sought for adjournment on the ground that a revision petition is pending before the Honorable High Court. Therefore, this court requires clarification, my lord, request clarification as to whether trial of this should proceed in view of the order dated 15th of February 2024, passed by Honorable High Court in criminal revision petition number so-and-so. Send the letter of request to the Registrar General, Honorable High Court requesting him to clarify the matter, whether the trial of this case would proceed further or not in view of the order dated 15 February 24, passed by the Honorable High Court in criminal revision petition number so-and-so. As per record of this office, scanned copy of record of the session case number so-and-so has been transmitted to the Honorable High Court on 15th of February 2024 through email. The case is adjourned today, fixed 21/9/2024 necessary order. Tomorrow the matter is coming. Now your Lordship will take a call. Where do the petitioners go? I won't be cross-examining the witnesses because I have not the due process of law as echoed down by the Honorable Apex Court in the judgment which I have a couple of minutes back referred. I won't be cross-examining because it affects my fundamental rights under Article 14. I won't be cross-examining the witness because the Learned Trial Court has not acted in a manner it should have acted as per the High Court's rules, as per the law laid down by the Supreme Court in the criminal trial guidelines. Or I should bow down and I should go ahead, which affect my fundamental rights. So this is the issue, my lord. Matter is of serious ramification. It has got a serious ramification. So what I will request, my lord, is that let an order be passed. Let me be protected in a manner, because tomorrow if I go and if I don't cross-examine on my genuine aspects, a cost will be imposed on me. Or if the Learned Trial Court closes my right to cross-examine, where do I go?
This order was passed by the Learned Trial Court below on 3rd of August.
3rd of August.
Therefore, what has happened? Does he give any clarification as he sought for? Or he or
No, it was, my lord, if your lordship will see the order was communicated to the Registrar General, so that it should have been placed by the registry itself. But for the reason based on to the registry, it was not been placed. So we made a mention. We made a mention before this honorable court that let this matter be listed. So accordingly, the matter has come up before this honorable court today.
Okay.
My lord, my humble prayer is that tomorrow the matter is fixed, so that in the form of clarification, my rights should not be scuttled down.
Okay.
My lord will pass the order.
Yes, does anything. At 2. Okay. Prosecution will file submit their submission at 2.
So I will join at 2 p.m. my lord.
Meantime, I also need a clarification from the registry that is the matter has been placed before the registry, or is there any clarification in that kind? I'll just ask the public prosecutor to take.
My lord, at 2 p.m. I will rejoin, my lord.
Yes.
I will rejoin. Yes. Okay.
To take just instructions, because the order he has been placed before us. It's an order passed by the Learned Session Judge in connection with the order passed by this court, and he is saying that he needs some clarification. The true registry it was placed. So just take it to a copy taken for the person. We'll resume it.
Always, ma'am. Example, like your lordship will appreciate that once the police begins an investigation and the investigation culminates in the form of charge sheet, under section 173, the IO files the charge sheet before the competent court. And for example, my lord, kindly take this example that prosecution relies have collected 10 sets of documents, 10 sets of paid documents. And in those 10 sets of documents, prosecution wants to rely on 5, thinking that it is their case. It is their case their case will be supported by those 5 documents. So accordingly, those 5 documents have been put in the form of, have been a part of the charge sheet. But the remaining 5 documents, they withheld it. And this practice, while the Honorable Apex Court was hearing in other matters, the Honorable Apex Court formed it as a criminal trial guidelines and found that the prosecutions in general withholds certain documents during which they recover or which they secure in the investigation, but withholds it so that the defense does not get those documents for their case. So now in the criminal trial guidelines, what the Supreme Court did that when you file a charge sheet, if you're relying 5 pieces of documents, it's fine, it's 173. And the other 5 documents which you are not relying, you have to give a list of those documents that I am not relying on those documents. And accordingly, it will be provided to the accused person under 207. And that was become a law, and that subsequently all the high courts, as far as us concerned, our high court, by high court notification number, my lord may kindly see the annexure, a list of dates, annexure P2, page number 36. Page number 36. Page number 36. Page number 23, my lord. Kindly come to page 23. My lord is there?
Yes.
Page 23. Your lordship will find that chapter 14, trial. My lord is there?
Yes.
Supply of documents under section 173, 207 and 208 CRPC. Every accused shall be supplied with statement of witnesses recorded under section 161 and 164 CRPC and a list of documents, material object and exhibits seized during investigation and relied upon by the IO. Relied upon by the IO in accordance with 207 and 208 CRPC. Explanation clause is there. Next page. The list of statements, documents, material object and exhibits shall specify statements, documents, material object and exhibits that are not relied upon by the IO. My lord is there?
Yes.
So this particular notification was being brought into force in light of the, kindly come to page 19. Kindly come to page 19. My lord is there? Page 19. Notification number so and so dated 29th of January 2022.
Yes.
Pursuant to order dated 24/2021 passed by the Honorable Supreme Court of India in suo motu criminal number so and so in re, that is criminal trial guidelines, the following amendments have been incorporated into the Guwahati High Court criminal rules and orders. So this is the order. This is the notification that has been brought.
Okay,
so what
now,
I am trying.
The case is fixed today for in order column. So now
Yes,
you
my
are
lord.
that the tomorrow date is fixed, and
My lord.
the trial court below had asked for some clarification from the registry itself. So I'm just asking the public prosecutor, what is the position at present? Was there any clarification from the registry?
With all due respect to this court, with all my humility in my command, I must say, the order which your lordship is seasoned with, that is 3rd August 2024. It is an order passed by the learned special session judge asking a clarification from the registry of the Guwahati High Court of this court. So in that context, I believe the role of the public prosecutor, learned public prosecutor, is totally negated from that side, because it is an explanation from the registry.
I am not on that. Now what the instruction he has received from the registry, that's what I'm asking. Here to public
PP has not received the instruction, I suppose, my lord.
I don't know. Let's just see. Yes, Mr. Das.
My lord, with all respect, I submit. The matter is as simple as anything. Nothing is there in the petition. My learned friend, through your lordship, first I want to raise a question for answer to my learned friend. Whether all list of documents and witnesses which are relied upon by the prosecution have been served or not to him.
That has already been.
That is done. Now only his grievance is this explanation, page 24. That unrelied documents. Petition is totally silent that there is any unrelied document in the hands of prosecution or in the hands of IO. Not a single document has been mentioned. That these documents were seized during the course of investigation. They are not relying on this. But an omnibus statement will not do. Yes, rules, regulations, apex court judgments are there. I know. But where is any allegation that any unrelied upon document has been kept hidden by the prosecution? Which document? Which witness? Nothing. And on that ground, the petitioner expects that the trial of the case should be stalled. This is not done.
If I buy the argument of my learned,
I have not completed. Please. I have not completed. When he claims that all documents are not given, some documents are kept hidden or concealed by the investigating officer during the course of filing the charge sheet, he has to specifically say that these documents were during the course of even from my hand it was seized by him, IO, and it is kept concealed. List of these documents or list of such witnesses were examined, but they are not relied upon. They have concealed these statements under section 161 of those witnesses. Nothing such allegation in the body of the petition. Absolutely no case, my lord. Absolutely no case. This is a petition liable to be dismissed in limine, my lord. What document has been concealed? Nothing has been said. Please tell us if any document is really concealed. Yes, I also understand. That will be prejudicial to accused persons. Because a judgment has been passed by the apex court, and without saying anything, you will come with a petition to stall the investigation or to stall the trial. That is not permissible in law. Absolutely no case, my lord. That is my humble submission.
Okay, and in regards to any other instructors from the registry or from the
No,
area?
I am not supposed to get any instructions from the because that has to be clarified by the court only. So, my lord, this is a petition to be dismissed, and my lord, trial court should be allowed to proceed.
If I may, my lord, to counter to the argument put by my learned friend, your lordship, with all due respect, I believe my learned friend has not understood the substance of the of this petition. It is not my case that which document is to be relied on, which document is not being relied. It is my case is that you carried out an investigation, you file a charge sheet, you are relying on certain documents which are part of the charge which has been given to me. Fine, that is a different chapter. The second chapter is that you are bound to give the list of the documents and material objects which you are not relying upon. What you carried out in your investigation. That is the essence. In that manner, in that aspect, how can I say which document is with you? It is your case, you should say it. That is the law. Now, my lord, your lordship will appreciate. This is as I begin, this is not this is an issue, it's not in a personam. I would say it has got a rather ramification. I can see my friends at the bar, in the bar, Mr. Biswas is there, I can see. What is happening in the criminal trials, criminal courts, he can also substantiate. It is not in my case as such. It is a thing which this Honorable High Court has framed the rules, which the learned trial courts are not complying with. It is your lordship's responsibility, that this Honorable Court's responsibility, how to maintain the judicial sanctity with respect to the laws and the guidelines. And as I have already placed that judgment, which recently passed by the Honorable Apex Court, that procedural aspects is an essence of Article 14, which cannot be tinkered with. I am ready to face the trial. That's why I'm not asked. If your lordship peruse my petition, I have not made a whisper with respect to the allegations made against me. It's a matter of principle. I am not asking for any adjudication to the FIR or allegation made in the charge sheet. No, not at all. I am with respect to the procedure. I am with respect to the procedure only. Now, if your lordship buys the argument of, or subscribe to the argument of the state, who has argued or made a submission in the bar without understanding the essence and contours of this petition, it's a very unfortunate situation. I am here to show that your majesties, this High Court's rules, that is a secretion of 227, that has to be maintained. The law laid down by the Apex Court in 142 and 141, that has to be maintained. If the law, if the state says that it's fine, let us go, then it is the most unfortunate thing. I hope my lord has appreciated the thing.
My lord,
I cannot hear your lordship.
No, there one other matter was there. That's what I.
now, Lord, I am not as wise as my learned friend is as a lawyer, my lord. I understand that. But my question to my learned friend is, suppose there is no document or no object which is not relied upon by the prosecution. In that case, what list will be furnished by prosecution or IO?
In that case, my friend, he has to.
Please don't interrupt. When you were arguing, I did not interrupt. Suppose there is no document, unrelated document. Where from the IO will find a list? If this is the essence of this rule, yes, I understand. Rule is there, Apex Court judgment is there, and we are bound by that. And this is a murder case, my lord. What list of documents you want? He has to specify. He has come with an allegation that unrelated documents are not listed. A list of unrelated documents are not given. Is there any unrelated documents? He has come with an allegation. He has to say, according to us, everything has been furnished to him which are relied upon. There is nothing unrelied. So where from the IO will furnish a list? Simple question, my lord.
There was the case of murder case.
My lord.
It's a murder case.
Murder case 302, my lord.
My lord will kindly come to page 12 of the paper book. Page 12 of the paper book.
Yes.
Page 12 of the paper book. I have extracted the para of the Apex Court, para 11. The amicus curiae pointed out that at the commencement of the trial, accused are only furnished with list of documents and statements which the prosecution relies and are kept in dark about other matters which the police or the prosecution may have in their possession, which may be exculpatory in nature or absolve or held the accused. This court is of the opinion that while furnishing the list of statements, documents, and material objects under section 207, 208 CRPC, the magistrate should also ensure that a list of other materials, such as statements or object documents seized but not reliant, should be furnished to the accused. It is here I pause it. What does the apex court says? Apex court says that it is a responsibility of the concerned court when the IO files the charge sheet, this particular aspect has to be looked into. Now, if we peruse that impugn order, which I put it to challenge, whether the learned magistrate exercise this power, kindly see. Pardon, my lord?
No, it's okay. You carry on.
So, if your lordship will see the page 40 P3, page annexure P3, page 43.
Yes.
My lord, is there? I'm just scrolling it down. Yes. P2.
So we are on P3.
Yes, my lord. Yes, P3. Order sheet of the magistrate's record. The IO of the case has submitted the charge sheet against the accused name. So and so of the accused person's names. One's case map or PO2 seizure list, 3 charge and seizure list, 4 inquest report, 1 PM report, 1 inquiry report, 1 FSL report, brief case of facts of case, serial number 16, 17 have been submitted along with the CS. Register as a case and place it for disposal. Where did the learned trial court, learned magistrates asked from the IO that what are the other documents you are not relied upon but you have collected in the investigation? What does para 11 of the Supreme Court judgment says? Now, kindly come to page 46, annexure P4. My lord is there?
Yes.
Your lordship, this is the order of 29/2022. Upon perusal of the report submitted by the IO, I am of the considered opinion that there is sufficient ground for proceeding against the aforesaid accused person under section so-and-so, and accordingly cognizance of offence under so-and-so has been taken against the aforesaid accused person. Accused person is on court bail, issue fresh summons to accused persons. Now, kindly come to annexure, page 125. Page 125.
Yes.
2012-2022. There, the compliance of 207. Copies of relevant documents as per section 173 CRPC and are ready and furnished to the accused persons in compliance with the provision under section 207 of CRPC. And committed the case to the learned sessions court. Now, on 15/5/2023, accused persons, namely so-and-so, are present. Seen petition number so-and-so filed by the petitioner, Prabhat Deka, bailer of accused Holiram Haloy, expressing his willingness to remain as bailer of accused Holiram Haloy. Accused Holiram Haloy is allowed to remain on previous bail. Now, your lordship will kindly see this order. I have heard learned counsel for the accused person as well as learned PP on the point of consideration of charge. On perusal of case diary and entire documents of record, I found prima facie material of offence under section 120B302 IPC against the aforesaid accused person. Accordingly, charges framed under 120B302 IPC against all the above named accused persons. Its particulars are read over and explained to the accused person to which he is pleaded not guilty and claimed to be tried. My lord will kindly recollect the NIA matter which your lordship was hearing with then Honorable Chief Justice, there were a lot of arguments have been made with respect to the contents of the charge. If my lord may recollect that the judgment also has been passed. If your lordship takes that or this order with those discussion which my lord has taken itself, does this order is a speaking order on the charge? Does there is an application of mine? My lord, it may be a murder case. That does not, there is an allegation that I have committed an offense. That does not mean that I have committed the offense. How grave the offense may be, the more rigor the procedure is. So what is my limited prayer? Kindly come to my petition. What is the prayer? Let us see the prayer. What is the prayer, my lord? Kindly come to page 15.
Page 15.
Page 15. 15, prayer. 15. 15.
Yes.
See the prayer. First, my lord will see the prayer, clause A. May be graciously pleased to admit this petition, call for the records, issue notice upon the respondent as to why the impugn orders dated 29/2022. That is, my lord, the learned magistrate's order in UPS case, and the order dated 15/5/2023, passed by the learned session judge, should be set aside and quashed. And your lordship kindly see, and remand back the session case number so and so from the court of learned session judge to the court of learned judicial magistrate first class, and restore the case as TUPS case number so and so, and direct the learned judicial magistrate first class to proceed with the case from the stage of receiving the final report under section 173 of the code, and to proceed with the case as per the rules stipulated in the notification number so and so, in light of the direction issued by the apex court. So what is my prayer? My prayer is I am ready to face the trial. I am not here. You just rewind it back, follow the due procedure. I am going to face the trial. And as far as my learned friend's argument that which document I am not relying, which document, how can he say? My lord, I have got two answers. First, the lordship will appreciate that a murder case, like for example, let us take this present case. There was a statement recorded of 10 persons. They are relying on 6 persons. What about the other 4 persons who might have said nothing against me, who might have said that these persons were not there? It can be. So it is their prerogative to say that these are the documents we are not relying upon. Second thing, if my learned friend is saying that the IO may not have any documents, then what is the problem of writing it on, bringing out on record that there is no other documents or list of statements or witnesses is recorded or we are not relied upon? And my lord, I am on a serious issue. The lordship may keep this issue that whether the learned trial courts, irrespective of this case, whether the learned trial courts are complying with this procedure or not. That is my humble submission, my lord. Tomorrow is the day. So tomorrow, if the witnesses turn up, my local counsel will be appearing and saying that he won't be able to cross-examine because of this particular proceedings. So if my witnesses, if a cost is imposed or if my right to cross-examine is foreclosed, where do I go?
Order will be passed.
Pardon, my lord?
Order will be passed according.
My lord. So, my lord, tomorrow we can appear before the court and make a submission on record that matter has been.
Entire matter will be disposed.
Pardon, my lord?
You have placed the argument entire. You have heard it at length. So, entire petition will be disposed of.
My lord.
Yes, any
Obliged.
other.
One thing I want to say that clarify, my lord. My landlord can be saying that 10 witnesses suppose examined by the IO and 5 have been relied upon. And this 5 where will go? My lord, after filing of charge sheet, the case diary is deposited in the court below. Everything is open. Everybody has access to that. Look, they can see how many witnesses are even in the charge sheet. Even from the case diary, they can compare that how many witnesses are examined and how many witnesses are relied upon. No such statement that such witnesses are withheld from the charge sheet. So these are vague allegations, my lord. Absolutely vague allegations.
Oh,
So we can hold it, my lord, dispose of.
the order maybe will be tomorrow, but yes.
In that case, my lord, I will just, in that case, tomorrow, since the matter, if my lord dispose of this matter in whatever way, so at least tomorrow I can make a submission on record before the learned court that kindly adjourn the matter for as far as us is concerned, because the matter has been heard and it will be disposed of. We are waiting for the order. So that can be placed. My lord, if your lordship will record that in order, so that tomorrow, if this particular thing is recorded,
No. I'll pass the order that will be disposed of. Suppose in that case, suppose we are not getting the certificate copy by today, it may not be because after 4:45 order. will
I
be
understand, my lord. I understand.
passed. In that case, you may make a submission that order has already been passed. By today itself, we may get the certificate copy. That
My
order
lord.
can.
My lord. Obliged.
Humbly obliged.
এইটো খালি হেৰি কৰি দিব।
My lord,
এইটো নহয়, এইটোতো দিবই লাগিব। তাকো এইটো কথা কৈছো। কিবা executive matter এটা dispose of।
My lord.
তেওঁলোকে আকৌ কালি Oh, it was part her. Oh, I thought it was so talented.
My
Yes.
lord, 3-year
You are item number?
45 IA. IA is for suspension of sentence, 1.5 year remains. 3 years, 6 months is the total imprisonment. My
3
lord,
years, 6 months was the total.
total imprisonment. He is behind the bar 4 days less than 2 years. So 1.5 year is remain, my lord. This is 2024 appeal. It will take some time for all this, my lord. So the sentence may be suspended 1.5 year, half year, my lord, less than 3 years. My lord, your lordship also for less than 3 years sentences are normally suspended because 2024 appeal, my lord, finally it will be heard probably in 2026 or 27. So 1.5 year already he has undergone custody because initially the charges was framed under commercial quantity. So he did not get bail, but conviction was given under intermediate quantity, 3 years, 6 months. So by now, the entire trial was took place as an under trial, my lord. He was an under trial.
Conviction was of intermediate one.
Intermediate one, 3 years, 6 months. My lord may see the operative part. I'll straight away take your lordship to page number 44 of the IA. Page 44, para 54. And para 55, period undergone by the accused during the course of investigation, inquiry, and trial is to be set off. And I have also annexed his forwarding report just to show that when he was arrested.
Apart from this ground of length of detention or the period of detention, what are the other grounds?
My lord, the other grounds, my lord, section 57 was not complied with. Because your lordship is aware, my lord, under section 57, a complete report has to be sent. There is no such report. 57 not complied with. 52 capital A not complied with. 52 capital A, there are 3 requirements to give a list of samples, photographs, and for drawal of samples, and all those has to be certified by the magistrate. Nothing done, my lord. Section 55 was not complied with. 55 says that the contrabands has to be deposited in the Malkhana.
Malkhana in charge, not examined. Malkhana register, not produced. All this ground I have taken, my lord. My lord, from LCR is there, my lord.
Lordship,
Feb
LCR
6.
is there, Lordship. So let it be fixed for final hearing, Lordship. Why next week, Lordship?
My lord,
Final hearing.
my lord,
Lordship. Then dispose of the-
experience tells us, my lord, hearing matters does not reach, my lord. Number one, day before yesterday, there was a hearing matter. Submission was made before vacation hearing matter, my lord. Hearing matter will take time, my lord. Let us be practical enough, my lord. This is 2024 hearing. Why it should have a precedence about the other hearing matters? We are still, there is a hearing list. I am not asking for suspending a sentence of 10 years. I am asking 1.5 year sentence. 1.5 year normally, my lord, normally, my lord, 1.5 year sentence are suspended. So that, because my lord, this hearing, then the judgment will also have to be passed. Whether your lordship will take up hearing matter before vacation. I'll have to take your lordship to PW1, PW2, PW3, the procedures and everything. He's not a very, my lord, high profile case that it has to have a precedence over the other hearing matters. This 1.5 year remains, my lord. The public prosecutor will also get sufficient time to, my lord, prepare the arguments and others, my lord. 1.5 year, normally, my lord, I have not seen now objecting for the sake of objecting is something else. But let us be practical enough, my lord, 2024 appeal. And if I want to, if they're ready for hearing, my lord, I can argue it today itself. We are at 2:30, within 1 hour I'll finish it. If she is ready, I'll argue today itself.
Orders are so let it be
Now, my
next
lord,
week,
my lord, we cannot say before vacation, these are bail benches, my lord, bail matters are urgent matters. Before vacation, normally bail matters, motion matters. I'm sure, my lord, before every vacation, the notification also comes up from the registry that only motion matters will be taken up. Hearing matters normally before vacation. I do not know, my lord, if there is an overnight change of events, my lord, but till yesterday, this was the rule, my lord. Before vacation, normally motion matters, bail matters, these are taken up. This is 1.5 year is left. Why to burden the court for a hearing? But and if your lordship is
there, Lordship.
LCR is there,
so we will finally dispose of the matter, Lordship.
my lord, I can argue today. If they say
It's an order stay there. Huh?
now, my lord, why all these technicalities now? Orders, admission, hearing, these are technicalities.
Just let me.
That's better. Now, just as because I was hearing the other matter, my lord, as an officer of the court, I'll just say what Siddhartha was arguing. He's arguing from Delhi. In Delhi, that procedure is followed in toto. While filing charge sheet, one list will be given, or if they do not rely, if there is no document which they are not relying on, I will give a note. That no further witness. This judgment. It was Siddharth Luthra was the amicus curiae appointed in that criminal trial judgment which is referring to. It is followed in toto in Delhi. I have the occasion to go through 1 or 2 records. But here, I can talk about Kamrup Metro. They do not follow this procedure. That I have also experienced. They will simply give some documents which they feel is benefited to them. If there is no such document, it is their duty to give a note or column that no such that the statements. These are the people's statement which we have recorded. There, we have not recorded any further statement, or we have not relied on any further document. That should have been the procedure as laid down. I'm not on the facts of the case, just whatever I understand, my. Yes. So my lord will take my criminal appeal because I have annexed the statements of the witnesses there. My lord, so let us go by the, we'll read the PWs first and then I'll come to my submissions, my lord. PW1 at page number 14, 14. My lord is there, my lord?
Page number?
Page 14, PW1. I am the informant of this case. On 24/9/2022, I was posted as the IC of Boro Bazar outpost under Bijni PS. On that day at about 4 p.m., I got information from SDPO Bijni over phone that 2 persons were carrying ganja in a motorcycle and proceeding from Panbari area towards Anando Bazar through PWD road. After getting the information, I entered the same in GD entry number, white GD entry number 356, dated such and such at the outpost. The SDPO also informed that I should make necessary arrangement for Naka checking, and he would come and he would be coming. He would be coming with an authorization letter. Accordingly, at about 5 p.m., I went to Naka checking at such and such PWD road along with following staff, namely 5 staffs. Para 3. We reached the PO at Naka checking at about 5:30 p.m. During checking, we noticed 2 persons were coming by 2 motorcycles. We gave signals to them to stop, but they did not stop. Rather, they continued to ride their bikes towards Anando Bazar side. Thereafter, we could stop one motorcycle by chasing and apprehended 1 person along with motorcycle. But another person fled away, leaving his motorcycle and a gunny bag. Another person fled away, leaving the motorcycle and the gunny bag. The apprehended person was later identified as Rajkumar Mondal. That's the appellant before your lordship. Rajkumar Mondal. The said Rajkumar Mondal told that the person fled away in Nitya. The person fled away is Nityananda. At the PO, I have recovered 2 motorcycles and 2 gunny bags. I have served written notice as per section 51 of the NDPS Act to the said apprehended person. Immediately after some time, the SDPO Bijni, Mr. Such and such APS, appeared at the PO. We also found a bag lying in the shoulder of the apprehended person, and we recovered the bag and found a small axe used for cutting ganja, a piece of flat wooden used for cutting ganja, and a chilam made by mud used for smoking ganja, a chilam made of brass used for smoking ganja, and a small knife having wooden handle used for cutting ganja. RC of motorcycle bearing number such and such in the name of Vivekananda Hajong, a orange color tobacco container, 8 number of key along with keyring and wooden handbag, elastic tools. We opened the gunny bag in presence of 3 witnesses and found 3 packets of ganja in one gunny bag and 4 packets of ganja in another gunny bag. We suspected that the said articles are ganja, cannabis, and hence we obtained a digital weighting tools and weighs the articles at the place of occurrence. After weighting, we found the following quantity of the cannabis as follows. In one gunny bag there are 4 bundles which are marked as A1 contains 5.270 kgs, A2 contains 5.350 kgs, A3 contains 4.130 kgs, and A4 contains 5.160 kgs. Total of the said 4 bundles contains 19.910 kgs of ganja. The said articles in a gunny bag was found in possession of accused Rajkumar Mondal, which was duly seized at the place of occurrence in presence of witnesses. In another gunny bag, there are 4 bundles which are marked as B1 contain 4.950 kg, B2 contain 5.14 kg, B3 such and such. Total of the said 4 bundles contain 20.475 kg of ganja. The said articles in a gunny bag was found in the possession of accused Nityananda Rai, who already fled away from the place of occurrence. Now, my lord will see, my lord, I just take a pause here. Just see the tragedy that has befallen on this appellant. Initially, they framed charges under the commercial quantity. They segregated both. Then, at the end of the trial, after 2 years, it was found that no, there is nothing prima facie to associate both of them, and therefore he is convicted under intermediate quantity. If the court would have framed the correct charge at that stage, he would have been out by 60 days. He could have been able to assist the trial, assist his advocate. But these are realities which are happening, my lord. In many cases, I have seen, my lord, they will club up. Anyways, my lord, page 17. Was duly seized at the place of occurrence in presence of witnesses. Another motorcycle was Hero Honda Splendor, my lord. The entire matter was video and audiographed at the place of occurrence. One Oppo mobile was also seized from accused Rajkumar Mondal. At about 10:30 p.m., I bought the articles, motorcycle and the accused to the Bijni police station and handed over to the OC along with the seized material and accused Rajkumar Mondal after conducting his medical examination. On the following day, on 25/9/20, I lodged an FIR to the OC of Bijni station. Exhibit P1 is the extract copy of GD entry number such and such, dated such and such, is my signature. Exhibit P2 is the authorization letter issued by the SDPO of Bijni, and Exhibit P2 is his signature. Exhibit P3 is the office order regarding issuance of authorization letter, and Exhibit P3 is the signature of the SDPO Bijni. Exhibit such and such is the seizure list of seized contraband and motorcycle and other articles, is my signature. Exhibit 5 is the seizure list of electronic weighing, measuring, and is my signature. Material exhibit 1, 2, 3 are the photographs of the accused Rajkumar Mondal along with cannabis recovered from him, and photographs of 2 motorcycles taken by me at the place of occurrence. Further examination in chief is reserved for production of seized material. Prosecutor, the witness has deposed in Assamese, and with the consent of the witness and the learned advocate, I have translated the same into English and thereafter. Now, PW1, further cross-examination, page 19. Today, I have appeared along with seized articles which contain a small axe used for cutting ganja, a small battle used for cutting ganja, a catapult, and a small piece of wood. I, along with staff, produced one accused along with seized articles at Bijni police station. Thereafter, I lodged the FIR. Exhibit 6 is the FIR, and exhibit such and such is my signature. The IO took my statement under section 161 CRPC. I also conducted body search of the accused by providing due notice in writing at the spot. Exhibit P7 is the notice to accused Rajkumar Mondal, and P7 is my signature. Under objection from the learned counsel for the accused on the ground that copy of the notice was never supplied to the accused, which is admitted by the additional PP as the same contained in the CD. That document not supplied, but relied. I have handed over the seized article at the police station, and the in charge of the Malkhana issued a receipt thereof. Exhibit P8 is the notice, and P81 is my signature on the receipt. The weighing machine was not, now cross-examination. The weighing machine was not examined regarding the correctness of its weight and measure. I have conducted body search of the accused at the spot. Before conducting body search, I was undergone body search by witnesses such and such, such and such, such and such. During body search, the SDPO Bijni was present, but his signature as witness was not taken. The seized articles was produced by me to the IO, who did not seize the same in the case. The seized articles was produced by me to the IO, who did not seize the same in the case. I did not mention the time of notice, White Exhibit 7. I have seized the articles at about 8:15 p.m. on 24/9/2022 and handed over the article to the police station by noting the date in the receipt as 25/9/2022 without mentioning the time. So, 24/8/15, allegedly it was seized. It was handed over to the police station on 25. Time not mentioned. The entire night the contrabands were in his personal custody. I'll come, my lord, whether this is possible under the NDPS Act, because the principle is that the more stringent the provision is, the more strictness of proof is required. Exhibit P7 was prepared by me at the police at the place of occurrence. Now, further examination of PW1, page 21. Today, I have appeared along with the seized. It seems it has been. I have annexed 2 copies of this. Yes. So that's done, my lord. For PW1 was prepared by me at the place of occurrence. It was prepared by me at the place of occurrence. My lord, may come to page 23. This 21 and 22, these are redundant pages. These have been annexed twice. So from 20, your lordship may come to page 23. I seized the articles at 8:15 p.m. and the weighing machine was seized at 8 p.m. The MR was prepared by the IO, not by me. The place of occurrence is about 10 kilometers from my outpost, and I started to proceed at 5 p.m. and reached there about 5:30 p.m. An entry was made in the general diary in this regard, but the same was not produced today. My staff were all together with me from the beginning. I have only recorded the statement of seizure witness. The seized gunny bag of ganja were lying with 2 motorcycles. Material exhibit 3 is the photograph of 2 numbers of motorcycle without any gunny bag. I have taken photographs in my mobile phone, which was not seized. The place of occurrence is the PWD road, and there is traffic in the road during day and night. It was darkness at the relevant time, and we had only torchlight. I have shown that the seized 2 gunny bags are supposed to be seized from the accused Sri Rajkumar Mandal. I have shown that the seized 2 gunny bags were supposed to be seized from the accused Rajkumar Mandal. I couldn't make out what he's trying to say. Anyways, man. Such and such number motorcycle was seized, but I had not found any document regarding ownership. It is not a fact that the accused was found in possession of ganjas and other articles seized by me, and due to direction of the superior authority, I have planted a concorded story. It is not a fact that the accused Nityananda did not come with the ganja in the motorcycle. The accused came at the spot about 10-15 minutes while we started checking. I had not made any entry regarding number of the vehicle bike passed on the road. It is not a fact that I had not followed the provision of section 50. Now PW2. I know the accused person who are resident of nearby village. One day the IC Borobajar outpost asked me to go with him. Accordingly, I accompanied him and reached at Ograng Bridge at about 5-6 p.m. After reaching there, I saw the accused Rajkumar Mandal was standing. The SDPO Bijni asked me to search his body, and accordingly I searched his body, but nothing was found. Thereafter, I found 2 gunny bags with ganja in the bag. The police also seized some articles in my presence. Exhibit such and such is my signature in the seizure list. Police also bought an electronic weighing machine for weighing the ganja, and subsequently the weighing machine was seized in my presence. Exhibit 5 is the seizure list, and Exhibit P5 is my signature. The police also took my signature on the notice served to the accused for his body search. Exhibit P7 is my signature in the notice. Then I left the place. Cross. The place of occurrence is 1 kilometer distance from my house. Many persons were present at the place of occurrence. I was a VDP secretary of my village. I cannot say the name of the person gathered at the place of occurrence. I cannot say who was the owner of the gunny bag. So, my lord, after interception, alleged interception, this man was called just to sign the seizure list. He has not seen the interception. He has merely signed the seizure list. Because when he was called, this Rajkumar, the appellant, according to him, he was standing there. Police asked to search him. So he has not seen Rajkumar carrying this. I cannot say whether police searched the body of the accused or not. I cannot say to whom the motorcycle belonged. The Exhibit 5 was not read over to me. I do not know what are the articles were in the gunny bag. He even doesn't know what articles were there in the gunny bag. I put my signature as directed by the police, and I do not know anything about the case. So, my lord, this independent witness does not lend any, it does not support the case of the prosecution. And when a witness is saying that I do not know what was there inside the gunny bag, and the foundation of the case is that the ganjas were in the gunny bag, why they don't declare him hostile? Because he is bought by the prosecution in the trial court to bring home what point? To bring home the point that he was carrying ganja. Now he says, I do not know what is there inside that gunny bag. He ought to have been declared hostile. Otherwise, this prosecution witness demolishes the witnesses of the other official witnesses. Now PW3, this is constable. On 24/9/2000, I was posted at Boro Bazar outpost. On that day at about 5-6 p.m., I along with the informant Sri Kumud Chandra Talukdar and official driver, some battalion personnel went for Naka checking at number 1 Agra village. Village. At about 8 p.m., while on the checking duty, found 2 persons were coming in 2 motorbikes. We gave signal to stop, but one of the person fled away and another person could be apprehended. Then we apprehended the person and 2 bags were recovered from 2 motorcycles. The apprehended person was identified by us as Rajkumar Mandal, who is present in the dock. We found suspected ganja in the gunny bag, which was seized by the informant. Thereafter, the apprehended person along with the seized article and bike are handed over at Bijni police station. No other person of the locality was present at the place of occurrence. I cannot remember the registration number of the motorbike. The informant did not take my signature at the place of occurrence. The place of occurrence is a public road and people used to go on the road. It is not a fact that nothing was recovered from the accused person and I deposed falsely. PW4. One day at 8 p.m. I went to Angra Bridge area by a motorcycle to bring my uncle Sri Bharat Borman from the place of occurrence. Then I saw police at the place of occurrence. I also noticed 2 bikes at the place of occurrence. Police took my signature. I do not know why the police took my signature. Others is a witness. This is how an investigation was carried out and a man's 2 years of life is being snapped. PW5. In the year 2022, I was posted as HG at Boro Bazar outpost and I was driving vehicle of the outpost. One day at about 6-7 p.m., the IC along with other staff went to Anando Bazar site. While we reached at Angra Bridge, we found the SDPO was already available. Then we waited there in the vehicle. Later on, I saw 2 motorbikes and 2 gunny bags. One person was apprehended by police who was identified as Rajkumar Mandal and present in the dock. Later on, we took the person along with gunny bag and motorbikes at Bijni police station. He's a home guard. Cross. I saw bikes separately and the bags are lying separately. So he has also not seen carrying of that. He saw 2 motorbikes separately and the bags were also lying separately. Then PW6, shopkeeper. Now, he is also called as an independent witness to support the prosecution case. I have a grocery shop at Boro Bazar, Bijni. I used the closed my shop at 6 p.m. One day at about 6 p.m. while I was closing my shop, police came and took my electric weighing machine. On next day early morning, police returned the same. Cross-examination declined. Then private driver. I know the accused person. I do not know the informant. About 2 years ago, I heard that police recovered ganja from the possession of the accused person. I had not seen the incident. This is how the trials get delayed, my lord. So these witnesses are bought in the trial, and I am sure, my lord, they must have consumed at least one witness will consume 1 month, 2 months. PW8. I know the accused person. I do not know the informant. About 2 years ago, I heard the police recovered ganja from the possession. Cross declined. 10. OC. Now this is important. Total witness. Now, my lord, this is the last prosecution witness, my lord.
PW9, where is the PW9? PW9.
Now, PW9 is not there. It is a mistake. While assigning number, they have assigned 10 and 11. Because I was also searching for PW9 because once 8 is there, ideally 9 should be there. Then I checked the record. There is no PW9. Your lordship may see the page number 45 of the judgment. There is a list of witnesses are there. Page 45 of my criminal appeal. page 45. नहीं, I का है ना? नहीं, इसमें भी I have even given the judgment here also ना? यानी कि judgment of patient. Yes, I got it. Page number 86. Just to confirm that, page 86. Prosecution witness, page 86. My lord is there.
Yes.
See, 8 and then 10, 11. So it is confirmed that there is no PW9. 35. On, that is 10. On 24/9/2022, I was posted at Bijni station and I was in charge of the police station. I received the FIR and registered the case and investigated the case. The informant also handed over the accused person to me and also handed over the seized articles found from the possession of the accused to me. During investigation, I prepared inventory, white exhibit P9 before the learned magistrate, and P9 is my signature thereon. The sampling of the seized articles were done in the presence of learned SDGM Bijni, and the samples were sent to FSL Guwahati, and subsequently I collected the FSL report. I had recorded the statement of all the concerned witness and also submitted a petition for disposal of the articles, and which was allowed, and the seized articles were duly disposed of as per law. Exhibit P10 is the prayer for destruction of seized article, and P10 is my signature thereon. So the articles were destroyed. It was not, the articles were not produced before the articles were not produced before the court. This is a very vital lapse, my lord. I'll take to the relevant judgments, my lord. The physical evidence should not be tampered with. The physical evidence of the case are the contraband and the seal which is used in the forensic science FSL forwarding report. The seal which is used in the FSL forwarding report, that seal and the contrabands, these are the physical evidence of the case. I had not, yes. After completion of investigation, I have submitted the charge sheet. PW11, Exhibit 11 is the charge sheet, and Exhibit such and such is my signature. During investigation, I had prepared a sketch map of the place. Such and such is the sketch map, and such is my signature. I had not received the article from the informant. The sketch map was prepared on 25/10/2022, which was mistakenly written as 25/10/2022 instead of 25/9/2022. FIR was received and registered on 25/9/2022 at 8:10 a.m. All the articles and accused was received on 24/9/2022. I had not cited the owner of the Yamaha motorcycle as the witness in this case. The seized Hero Splendor bearing number such and such belongs to Tapos Chakraborty, and he was also not enquired or cited as witness in this case. It is not a fact that I had not recorded the statement of SDPO Bijni. I had not recorded the statement of police personnel who was in charge of the Malkhana. The photographs of the seized material while waging was taken by the informant at the spot and handed over to me, which I had annexed with the case record. I cannot say who inserted the police station case number thereon. It is not a fact that I had not properly investigated the case, investigated the case and falsely implicated. These are suggestions. 38. Oh, there is one more, my lord, PW11. In the year 2022, I was posted as the Scientific Officer, Drug and Narcotics Division, Director of Forensic Science, Guwahati Kahilibar. On 26/9/2022, a requisition was received in connection with On 26/9/2022, a requisition was received in connection with Bijni PS case number 7 regarding examination of 8 parcel under seal. 4 seal cloth covered marked as such and such, each containing 25 grams dry plant materials in each. Other 4 covered such and such, each containing 25 gram. After examination of that, I found that all the samples mentioned above gave positive taste of cannabis. In this regard, I issued a. Now, my lord, kindly see. When he received this, 26/9/2022, when the seizure was made, 24/9/2022, where these contrabands were from 24/9 to 26. No Malkhana register exhibited. My lord will see the receipt कहीं पे दिया था, एक receipt here, एक receipt वो लोग ने दिया था, हाँ, receipt, हाँ, और one second, now my lord will kindly appreciate this. If I understand the procedure of the NDPS correctly, my lord, then what they do, once the seizure is made, my lord, they will go and keep it in the Malkhana of the police station. They will enter it in their Malkhana register that at such and such time, is it? And it will be countersigned by the Malkhana in charge. Then when, because there are 2 times, in fact, 1, 2, 3, 3 times these are entry exit business will happen 3 times. Next day morning, again they will bring it, they will produce it before the court for drawal of sample, 52 capital A. Then again it will be bought and kept in the Malkhana. Then again it will be taken out and sent to the FSL. Any Malkhana registered showing who has taken out the contrabands from the Malkhana for producing it before the magistrate, who, when, at what time, is there is anything on record to show even remotely who and at what time it was again re-entered in the Malkhana after drawal of the sample? Who, by what document those samples were again taken out from the Malkhana to send it to the FSL? After 48 hours, these samples reaches FSL. How? Who is the messenger? Is it by a messenger? Is it by post? How? I was, huh? Yeah. So, my lord, the purity and the sanctity of the samples are of paramount importance to entail a conviction under the NDPS Act. Time and again, the Supreme Court has laid down, my lord, it says that from the time the seizure is made till it reaches the FSL, there has to be, the chain of custody has to be proved beyond all reasonable doubt. That's the basic requirement to entail a conviction, my lord. In whose custody these samples were, I do not know. Who has kept it? Nothing on record. Now, my lord, my arguments. I guess. My lord will kindly come to page number 6 of my appeal memo. Ground number 4, page number 6 of my appeal memo. So, my lord, thankfully, while preparing this appeal memo, I have so that is why, my lord, extempo argument could be made. Otherwise, my lord, if I would not have prepared the arguments in the appeal memo, then it would have been difficult because the arguments are already there in the appeal memo. Page 6, ground number 4. As per seizure list, that is Exhibit 5, the alleged contrabands were seized on 24/9/2022. My lord, page 6, ground number 4, my lord, is there. My lord may verify all these things because I have, my lord may verify the seizure list. The seizure list would be there in the record, my lord may see. the seizure list would be dated. The learned public prosecutor may correct me if I am wrong in this date. But I have, I mean, sir. He's not paid for it. He's only paid to object. So, my lord, as per the seizure list dated 24/9/2022, Exhibit 5, the alleged contrabands were seized on 24/9/2022 at 8:15 p.m. This fact is also corroborated by PW1. Now, as per the deposition of PW11, the said contrabands were recovered on 26/9/2022, were received on 26/9/2022 in the Forensic Science Laboratory by a special messenger. Now, PW1 stated in his evidence that I have handed over the seized articles at the police station and the in charge of the Malkhana issued a receipt thereon. Exhibit P8 is the notice and P81 is my signature on the receipt. Now, firstly, Exhibit 8 relates to a GD entry dated such and such and not 24/9/2022. My lord, kindly Exhibit 8. Exhibit 8 to put on. Exhibit 8. Exhibit 8. 7. Yes, this is Exhibit 8. My lord, page number 55, if your lordship sees in the appeal memo, is Exhibit. Now, this is a typed copy of it. This is not a Malkhana register. This document, anyone can print this document at any place. What is required was a Malkhana. Now, what this document says, because this document was exhibited to show that it was kept in the Malkhana. I, Sri Kumud Chandra Talukdar of Bijni PS, do hereby hand over the seized ganja in connection with Borobajar OP such and such to ASI Pran Krishna Ray for doing the needful and keep safe custody. It is Pran Krishna De. Now, whether Pran Krishna De have been examined? Pran Krishna De to list of witnesses. The list of witnesses, Pran Krishna De's name, whether Pran Krishna De, no. Pran Krishna Dev was not examined. The person, according in whose custody the ganjas, and my lord, this also does not satisfy the test at all, because the ganjas were taken out twice and entered twice, once for court, second time for FSL. Nothing. This document does not help in any way to prove the chain of custody. And moreover, the person in whose custody it was given, Pran Krishna De, not examined. 114 illustration G of the evidence set, the old evidence set, of course. Adverse presumption. Now, firstly, Exhibit 8 relates to a GD entry dated 25/9/2022 and not 24/9/2022. Now, my lord, now there is one more defect in this Exhibit 8. My lord will see this relates to a GD entry of 25/9/2022. Seizure 8:24. Entire night where it was. This, even the date, if your lordship sees, because this is in relation to a GD entry of 25. Seizure on 24. So 20. At what time? 25/9 time? No. Wait. Fine. This is a pertinent question. I'll try to find it out. But as usual, my lord, they will not comply with times. They never put time in.
After 4 hours, it will be 25.
No. After 4 hours, it will be 25, sir. It is the duty of the prosecution to write the time. No. This is the page. The time is not there. Time is not there. Page. My lord will correct me. Page. You can also cross verify page 55 of the appeal memo. তাতে কিবা সময় যদি দিয়া আছে চাই লওক page 55 মোৰ তো চকুত পৰা নাই I have not found it.
But somewhere it is written, I think, at about 25th in the morning hours, 8:10 most probably.
Yes, that is my point, my lord, where the ganjas were for the entire night. They will never give time. Why they do not give time, my lord? Because they want to keep all this open. They will, so that they can, while in the court, they can argue morning, 12 o'clock, midnight, 1 minute after 12 o'clock in the midnight. So they keep it all this open. I have never seen, even in the authorization letter, in all NDBS cases, they will never put the time. They will leave it for the argument. Now, my lord. Yes. Now, Exhibit 8 does not contain any time or date as to when it was entered into the Malkhana. I have made it a ground of in my appeal. Exhibit 8 does not contain any time or date as to when it was entered into the Malkhana. Neither date nor time. It simply says Kumud Chandra Bijni do hereby hand over the seized article to ASI such and such for doing the needful and keep safeguarded. When? At what time? Nothing. Thirdly, whereas other documents were produced on 25/9/2022 before the learned magistrate and are marked as seen by the magistrate, Exhibit 8 is not marked as.
One thing. Page 55 question, no?
Right.
GDNT number 356. Dated, your lordship may kindly see.
24.
24. Here we have 55 page. Your lordship may kindly see. This is dated 25/9. This is Borobajar outpost, my lord. I do not know where from this document has come, who has typed it, or my lord. Yes, that is original. Original GD entry is there.
Okay, submit that.
At 4 p.m. That entry is made at 4 p.m. Time is recorded.
A document from record of the
GD entry, we are concerned with GD entry.
This is the Gudam receipt. We are not, I am not arguing on the GD entry. This is the Gudam receipt, page 55. Whether this original.
You talked about GD entry number. GD entry dated so and so, 356.
Yes, but this document.
This is not dated 25/9. That is 25/9.
It is not for the defense to put the date. I am saying whether Exhibit 8 exists in the original record or not. Apni hetu sakna Exhibit 8 to ase na.
8 to challenge korcha na. GD entry number.
Exhibit 8 to
25.
Exhibit 8 to 25 likha thake mo 25 e kom no. Exhibit 8 whether it's just the exhibit file. I'll just verify whether Exhibit 8. Exhibit 8. Exhibit 8. Exhibit 8. It exhibit file है ना? Interest something very. There is no exhibit marking also they are not doing. 10. Exhibit 10. Exhibit 8 to ever.
GD entry cannot be made because Caesar was made on 24th. And this he was bought.
Let us see what is written in the Exhibit 8 to like Exhibit 8 to is important. Exhibit to LCR. Whether this exhibit 8 is there, my lord?
No, it is CD only.
Or CD.
Exhibit file pahana nahi. Exhibit file is not there.
No, the FIR, there is no marking this.
A1 file is there.
Software have got a cut, but it's enter method CD only.
File C is not there.
This is CD only.
Receipt, you know?
No, CD. This is CD,
Oh,
not
this is
not
CD.
the exhibit exhibited.
No. Exhibit as exhibit 26. Kiman number 1 exhibit?
Exhibit 8. Interestingly, Caesar leaf exhibit number না।
এক্সিবিট করেছে আমি এটা কার্বন এই ফটোকপি
Exhibit বুঝে মারে একটু।
মানে এক্সিবিট কি কোন তো
Exhibit
এক্সিবিট
8 কত? Where is exhibit?
এক্সিবিট 8
Exhibit 8. Yes, it is written 25 in the original copy. It mark করে দিও, flap দিও, flap দিও। I thought whether there is any manipulation from the end of wait, because exhibit 8 mark করে দিও। Now it is for the prosecution to explain why they have written 25 or 24. It is a document not prepared by the defense. It is there in the record, my lord. So this page 55 is correct. Now, moreover, my lord, this page 55 does not speak when and at what time and when. The date and time is not mentioned. When and at what time it was entered. Then, my lord, thirdly, whereas other documents were produced on 25 9. Now, this is very important, my lord. All other documents, Caesar list, FR, those were produced before the magistrate on 25/9/2022 because there was a scene that magistrate seized. This document was not produced. This document was later on manufactured because I don't see any scene mark in this exhibit 8. I'll verify for the record also. X second at about side. Scene as in no. Nine. No. For the other documents, the magistrate has marked that scene, but this document was not produced before the magistrate. Fourthly, exhibit 8 is claimed to have been signed by one, page number 7, my lord, signed by one ASI Purno Krishna Ray, but he has not been examined. Exhibit 8 is not being proved. So thus, my lord, if the author, the author of the document does not enter the doc, then the document cannot be proved, my lord. It is the author of the document should enter the doc and say, yes, this is signed by me, and he should exhibit that document. Further, there is nothing on record as to by whom and when the contrabands were taken out from the godown to be produced before the magistrate and when the same was again entered. There is nothing on record to show as to when, date, time by whom the samples were again exited from the godown for sending the samples to the FSL. There is nothing on record to show as to what seal was affixed on the samples because there is no mention of any facsimile of seal in the FSL report as well as in the evidence of any of the prosecution witnesses. Now, how do we connect the Caesar with the FSL report? It is the seal, the facsimile of the seal. That's the connecting link. How do I know, my lord, that the contrabands which were seized on 24th night allegedly were the same contrabands which were sent to the FSL? It is because, my lord, your lordship, my lord, have come across the trials of NDPS trials, my lord, that facsimile is being put in a separate piece of paper and it is sent along with the samples to the FSL. Then in the FSL report, they mention that we received a ganja with such and such seal. And that seal will also be affixed on the samples. That is how the Caesar samples and the report gets connected. Then there is nothing. Now, my lord, when there is a doubt regarding who has taken or since there is the chain of custody has not been proved, the best evidence would have been the messenger who has carried it. He could have said that at such and such time I have received it from such and such place and this is the same ganja I have gone and handed over to the FSL on such and such date. That would have at least saved some grace for the prosecution to connect the ganja with the FSL report. That yes, I collected the ganja in connection with X case from Mr. Y and I have gone and submitted it to the FSL. At least this evidence should have been brought on record. Neither the messenger who according to the prosecution had carried the contraband to FSL were examined, nor his name is disclosed. Even the name is also not disclosed. Who is this man who has carried the ganja? Furthermore, the Malkhana registered were also not produced to prove that in fact the contrabands were actually kept in Malkhana and that the same were taken out from the Malkhana to produce before the FSL. The prosecution has thus miserably sold to chain of custody. So this was my argument regarding the chain of custody, my lord. Now, my lord, 8 duplicate samples were drawn. I have not come across a case where the duplicate samples were not produced in the court. What is the purpose of drawing a duplicate sample? The purpose of drawing a duplicate sample with the same facsimile is that so that these samples are produced before the court, so for the court to see that in fact samples were drawn. It is for the court to see and satisfy. That is why these duplicate samples are drawn. 8 duplicate samples, none exhibit. Now there is no, they have not produced it before the court. Perhaps they have destroyed the samples also. They are so scared that since we have cooked up a story, if you produce this duplicate sample before the court, it might turn out to be a grass. I was not present there. For that, the 3 independent witnesses whose signature appears in the seizure list, the prosecution had examined 2. Now, as far as the independent witnesses, the name of 3 independent witnesses appears in the seizure list, but they have examined 2. Fine. Now, PW2, he says that the exhibit 5 was not read over to me. That is, exhibit 5 is the seizure list. So here is a man who does not know where he is putting his signature. But section 100 of the CRPC is also applicable in a seizure under NDPS Act. Section 100 is applicable under NDPS Act. Section 100, if I remember correctly, my lord, it says the legislature must have chosen the word with some wisdom. Says respectable persons of the locality. They could have called some dukandar because it was in the highway. Highway means infested with people. There were shops.
One VDP secretary was examined.
The VDP secretary has further destroyed the case. One person says that I do not know where I have put. VDP secretary say I don't know what was inside the bag. PW2 say that exhibit 5 was not read over to me. I do not know what are the articles were in the gunny bag. I put my signature as directed by the police and I do not know anything about the case. This is first independent witness. Second independent witness, PW4. He says, one day at about 8 p.m. I went to...
Okay, don't repeat.
Agrawal. Thus, none of the independent witnesses implicated the appellant with seizure of the alleged contraband. None of them has implicated with seizure of the contraband. PW2 stoutly denied to know anything regarding the case and PW4 clearly stated that he does not know why police took his signature. That's the bottom line. PW2 stoutly denied to know anything regarding the case and PW4, he doesn't know. None of the 2 witnesses were declared hostile. Hence, PW2 and 4 had belied the official witnesses as they did not attribute seizure of the contraband from the possession of the appellant. Now, my next ground is there is an absolute non-compliance of Section 57. Section 57 of the NDPS Act mandates that a complete report of search and seizure will have to be sent to the superior officer within 48 hours.
48 hours.
48 hours probably, if I remember correctly. One is 48 hours and that is 72 hours, 48 hours. Nothing. No. 42(2) of the NDPS Act has also not been complied. No compliance report under 42(2) has been sent. Then, my lord, 52A. Now, my lord, Section 52A has 3 conditions. Condition 1, you apply to the magistrate for drawal of sample. Condition 2, you make a list of samples, place it before the magistrate for certification. Condition 3 is regarding the photographs. and an inventory has to be made with a certification. The magistrate should certify. Just merely placing an inventory without certification is of no use, my lord. Now, my lord, if I produce an inventory and if the magistrate does not certify, the legal inference would be this: the inventory is not correct. That is why the magistrate has not certified it to be correct. Now let us see, my lord, in this case, whether they have complied with this condition or not. Their inventory. The inventory your lordship will find at inventory ka copy. Inventory ka copy. It is exhibit inventory. Yes. Exhibit 9 is the inventory. Exhibit 9 is the inventory. Now, my lord, apart from this inventory, there is no list of samples as mandated by 52A. Yes, certifying the taking in the presence, allowing to draw representative samples, magistrate. Taking in the presence of such magistrate, my lord, the mandate of 52A, subsection B, subclause, subsection 2, subclause B I am reading. An application has to be made for the purpose of taking in the presence of such magistrate photographs of such drugs, substance or conveyance and certifying such photographs as true. The photographs has to be taken in front of the magistrate and a certification regarding correctness of the photographs is to be given by the magistrate. Then allowing to draw representative samples of such drug or substance in the presence of the magistrate and certifying the correctness of any list of samples so drawn. List of samples, there is no list of samples. The photographs, there is no certification. Only this 52A inventory was prepared. However, my lord, this inventory was who has bought the ganjas? It is not there, my lord. Now, my lord, my next theme of argument is
Let's come below the last para of 56, page number 56, exhibit 9.
page number 56.
Just exhibit 9 only. 9.
Yes, 56. Yes, my lord.
See, there is the certification.
Certification is there. There is a certification is there. Certification is there regarding the inventory.
Okay.
Yes, but my lord, the certification regarding the list of samples and the certification regarding the photographs. Because there are three conditions. And these are not or, and. 52A, because 52A received a massive interpretation by that judgment, your lordship is aware, that Mohanlal judgment. In Mohanlal judgment, that sampling before the magistrate, in fact, in Mohanlal, nothing new was said by Supreme Court. Supreme Court has just said what is there in this statute. You follow this because there was a standing order 1/89. That standing order, according to that standing order, samples were to be taken from the spot. So there was a conflict between a standing order and a statutory provision. Mohanlal settled it in favor of the statute. Then in Mohanlal, it was further clarified that not only this certification, but also list of samples and this. So, my lord, it is there in the statute, and therefore, my lord, I am not burdening this court with those judgments because it is there in the statute itself. Now, what that the three independent witness with signatures? Yes, the independent witness gone because independent witness is section 57 not complied. 42 I argued correctness of inventory was produced before the court for the certificate. Neither any photographs were exhibited nor any certificate certifying the photographs were true was produced before the court. My lord, what happened? I just got confused in one because this inventory was yesterday. I was preparing another NDPS case. In there, the inventory, there was no signature of the magistrate. So since today it was an extempo hearing, my lord, I am doing, I came for orders. So therefore, that just skipped my mind. So I'm sorry for that. Here, this certification is there because in that case, the certification was not there. So for it just skipped my mind. Yes. 42, this is gone. I argued this photographs certification not done either. Then para 10. For that, there is a non-compliance of 55. Yes. Now, 55, section 55 says that it has to be in the safe custody of the officer in charge. Section 55, that is what section 55 says. An officer in charge of the police station shall take charge of and keep in safe custody pending the orders of the magistrate all articles seized under this act within his local area. None of this section 55 was absolutely not complied with because we do not know who was handling or dealing with this contraband. Now, my lord, these are my basic arguments, my lord. These are on facts, my lord. These are my basic arguments because that chain of custody gone, my lord, in this case. There is nothing to connect even the FSL forwarding list of exhibits. Even the another vital document which they have withheld, not produced, which will draw an adverse inference, is that forwarding letter. Because it is that forwarding letter along with a facsimile which will connect the report with the seizure. Because, my lord, the principle, if I understand correctly, subject to correction, is that the more stringent the provision, the more strictness of proof is required. Because there was a conflict between, there was, my lord, till 99, that 99 till 96 or in the 90s, the principle was substantial compliance. That for NDPS, if there is a substantial compliance, conviction can be given. Then the Supreme Court says no substantial compliance, strict compliance. Then came the doctrine of strict compliance. In cases where there are stringent provision, section 37 is there, your lordship, where there is stringent provision, substantial compliance will not do. It has to be strict compliance. Those judgment, my lord, I will place for seizure and everything, my lord. On facts, if you want to argue those judgment, my lord, I have not bought the judgment today. I'll just give a hand wrote judgment. And otherwise, my grounds, my lord, I have already mentioned in my appeal memo. These are my basic grounds, man. I'm obliged. Within 1 hour, I completed. Judgment oh, fine. Now he wants that what judgment I will place. He wants to know about the judgment. Fine. I'll satisfy everything.
No, if he has not completed, let it remain as part. I have no objection. But he has to complete first his argument.
Acha. I have judgment. Index. Judgment index. Index. Index.
Tomorrow, I mean,
tomorrow we are not
Monday, from Monday, it will be, I'll be in another batch. So it cannot be possible.
That is the precise reason why I was saying. But anyways, my lord, a judgment I'll give. My lord, I don't remember the names. I'll give the names. I'll give the citation. Let him complete, my lord. Within 10 minutes, I'll get it from my channel.
No, I cannot complete like this.
My lord, then
I have to apply. I have to reply your contentions.
If you want to.
My lord,
may I suggest one thing, my lord? As it appears, he is also not fully prepared. A number of times he has said that extempore argument he is making.
No, but I'm done, my lord. I'm done with myself.
Let it remain as part. We will argue later on, my lord.
No, my lord, just to oppose my IA, I was made to argue now, my lord. This is not fair. This is not fair.
You wanted to argue. We did not make you argue. When we opposed the bail, you wanted to argue.
No. They were saying that it's for hearing. Then he said you argue.
Otherwise,
that is why I told at the first instance that this has come for orders. This is for IA for suspension of sentence. Only 1.5 years remained with all this factual evidence, my lord, let it be suspended. 2024 will come for hearing. They started objecting, my lord. And then they said, why Kora argument? Then they took the LCR.
So we should not object.
No. You said Kora argument. You should not
Argument,
object.
you wanted to argue on merit.
Now, my lord,
When
whether
my
he wants to
learned friend
argue or
said-
not, I do not know.
My lord, when my learned friend said that LCR is easy, let the entire matter be disposed of. This is NDPS case, my lord. That is why my learned friend said that. But he was, no, if you want to argue, I am ready to argue today itself.
Otherwise, he most probably concluded his argument.
Yes.
Except his citation, this judgment.
I completed my
Yes,
argument.
So relied on.
My lord.
That part is left.
I completed my argument. In rebuttal, I'll give the judgment.
I can fix it as a part out on Monday, but that is not sure about it because
Let us try on Monday.
My lord, then let it be tomorrow, my lord, because Monday, if your lordship
Tomorrow
is
we
in
are not
other bench.
coming. Tomorrow I am not coming.
Acha.
You
No.
may come.
Acha, you got a point over me. I can understand. So Monday, your lordship will be in outline benches,
no. Here only, but we have a division bench.
division bench.
This division bench, several hearing matters are there, so may not be possible. If it is possible, I'll talk to the registry so that it can be fixed. And if it's half an hour, around 15 minutes or half an hour, it can be completed, then I'll take it. But the question is that at present, I cannot say. Monday, if the time permits, then definitely I'll take.
My lord, if
As Monday.
since they are taking the excuse of this, my judgment, this, my lord, one or two items will be at least left in the list. Arsenal item, Arsenal. My lord, within 10 minutes, all the judgments will be 10, not even 11 minutes. Within 10 minutes, I'm giving it.
What time? 10 minutes. Other don't give for any number. These are all for order matter. What is the about it?
Lordship, service already completed, Lordship. As per Lordship, kindly see Lordship, last order, Lordship. Your Lordship, order passed, Lordship.
Anyway, service is already complete.
Lordship. Last occasion, Lordship.
The state is 41, return number,
Yes.
respondent 1.
All-
In body matter.
Both the matters, Lordship. Lordship, issues, Lordship, NBW was issued against the Lordship, this petitioner, Lordship. Now, Lordship, back of the case is that, Lordship.
No, we are not on fact. We are not going to hear the matter. What is about the, it is an order column.
Order column, Lordship.
So now you are saying that service is already
Already
complete.
completed, Lordship. Lordship, similar, identical
Also,
case,
Lordship.
Lordship. My lord,
Okay, then represent number 2 has not been represented by anyone. Na?
Lordship.
So can you
Lordship, kindly-
fix on admission column to both the matter?
Not to admission, if no one appears on that day, then legally it may be appointed.
Lordship, NBW issued,
So,
Lordship.
legal aid? What is the case? Nature of case?
Lordship.
Oh, POXO is there.
POXO is there,
Oh,
Lordship.
Lordship, after 6 months, Lordship, FIR was filed, Lordship.
No,
And
no, whatever.
no, Lordship, I am not on merit. No. Similar, Lordship, situated person, Lordship, came before the same, Lordship, in different, Lordship, police station, Lordship.
No,
But
now
cases,
POXO matters.
Lordship, same,
Up
Lordship.
to one.
Same, Lordship, 376G and POXO, Lordship. Kindly see, Lordship.
What you want to submit?
Lordship, this NBW issued, Lordship, on the first day, Lordship. Even, Lordship, charge sheet was, Lordship, filed, Lordship, stating.
that you are declared absconder.
Yes, Lordship.
Absconder. Only he wants recall of the Millard.
Well, Lordship, NBW, Lordship. And I
And he want to face the
What
trial.
if the ground you have brought that why you are not appeared before the
Lordship, during the Lordship investigation of the case, Lordship.
You were absconding.
No, Lordship.
Then?
I am not in the Lordship place of occurrence, Lordship. I am in Chennai, Lordship. After 6 months, Lordship, this FIR was lost,
The
Lordship.
6 months, you stop saying 6 months.
Lordship.
What is your problem now?
Now, Lordship, I am ready to face the trial, Lordship. But Lordship, this NBW, Lordship, police is searching,
Where is the
Lordship.
order? Order.
Lordship, kindly see, Lordship. page 35, Lordship.
30.
35, Lordship. From Lordship, page 33 onward, Lordship.
Yes, that is it.
First order was Lordship, page 33, Lordship.
No, you have annexed the order of most probably not the initial. It is the order dated 22.
What about
to 1
earlier
with the
orders?
earlier order.
Earlier order is 22-1, Lordship.
Page,
First
page.
order, Lordship. Page 33, Lordship.
It cannot be. It cannot be first order.
Lordship, I
When the
have
charge sheet was filed?
Lordship,
When charge sheet filed, when the record come, the
Lordship,
FBR file any order.
page 27, Lordship. Finally, say charge sheet.
No. Order will have 9 record.
Page
Charge sheet
27.
was filed
Not
on
the order.
30 September 2023. How this can be first order then?
Lordship, I am.
You have not annexed the all orders.
No, Lordship,
After filing of charge sheet, order of cognizance is there, everything.
In that
Sorry,
case
this is
only
the
we will
27
to
one.
know that
27
issuing any
Yes.
summons
there is the
for being
It was Pishore order, it was Agur order,
it took
23.
23. It took first order.
এইটো ফার্স্ট এইটো চার্জ শিট সাবমিট কৰিছে তোমাৰ 30 সেপ্টেম্বৰ 23
23.
8/30/9/23 পিছত কি অৰ্ডাৰ আছে ইমিডিয়েটলি পিছত
now your
That is
submission.
cognizance now, na?
Mr. Counsel, your submission in that line
Lordship.
that on the first day of order the NBW was issued.
Yes,
Yes,
that is
Lordship.
that is his
Yes,
contention.
Lordship.
It is not there.
First cognizance has to be taken.
Yes.
Thereafter,
Yes.
question of summoning you will come.
Order is if someone.
Where is that order?
Wishing
Lordship, I am
Cognizance.
giving, Lordship, I have this total, Lordship. Entire order sheet is there.
You
Lordship.
bring that order on record.
Lordship.
No?
you have to bring on.
Cognizance order you think
Lordship, I am giving.
he has to annex the cognizance order. Miller.
Obviously, it's
Then only we can come to conclusion whether
you are submitting in this and you are not prepared. I have not filed any the order sheets in all the order sheets. All the order sheets mean all the orders. I have to file it.
Lordship,
You are
Party
Mr.
can, Lordship. This is the order.
Submit it. It should be on record.
charge sheet along with no, you have to bring it on record, na.
Lordship.
With a view. আচ্ছা এইটো order এইটো ইয়াতে কি হল 22 তাৰিখে
22 তারিখে NVDW. এই টু আমার 33 পিস।
এইটো তুমি এফিডেভিট ফাইল কৰা এটা
File an affidavit.
charge sheet along with submitted responding.
We are listing it after 1 week or maybe not this week. Not this week. I mean next week we have.
Lordship.
You are
Next week,
Mr.
Lordship.
You are Mr.
বি মালাকার।
Bima. Both the matters over hard Mr. Bima. We are a copy for the paper.
ইয়াৰ কোনটো
Lordship, there is a difficulty, Lordship.
Everyone will have a respondent. From the order dated 16/9/2020, it is seen that the notice is duly served on the but still this phone number to be made. Next, Mr. Malakar submitted order that the present petition has been filed against the order of issuance of NBWA, which was issued at the first day of after the receipt of the notice charges by the learned trial court below, without issuing summons to the present petition. But on perusal of the record, it that all orders are not been annexed in the present petition. In that context, Mr. Malakar submitted that with filed an additional affidavit, to which all the orders. This demand number 1 Arabic petitioner to file all the orders that order sheet in the form of it. Yes, what are submitting?
Lordship, actually, Lordship, petitioner, Lordship, second petition, Lordship. The petitioner is in Chennai, Lordship. Now, Lordship, for showing the affidavit, Lordship, it is so difficult, Lordship.
No, সেইটো এফিডেভিট হেৰিটো কৰিব পাৰে নহয় তোমাৰ ঘৰৰ মানুহে কৰিব পাৰিব ইয়াৰ এফিডেভিট কৰি ফাইল
Petitioner here. Petitioner, he himself is the petitioner.
Lordship.
Then by someone could have find if it is
মানে আদাৰকে লছে দিব
All Lordship,
তাৰ ভাইক চাই হেৰি চাই নাই
আচ্ছা, দেখো, আছে।
দেউতা
Now, Lordship, there is another difficulty, Lordship, registry, Lordship. Whether Lordship, this, Lordship, if your Lordship.
No, I cannot pass.
No, these are your problems. So we are to solve it.
It's your problem. It's
Oh, this is not
Well, Lordship, I
problem.
mean, simply, Lordship, with a request, Lordship, bring their order record.
He is showing you a way that it may be accepted by the race. That point only. That part, how can we guide you?
No, Lordship,
Cannot pass any orders.
no, Lordship, if I, Lordship, with a request, Lordship, file this order, Lordship,
He
with the
is now,
receipt.
you are saying that he is ready to appear, ready to cooperate. Now he is still in Chennai. So what kind of thing you are expect? This after 1 week. OT method. Active timing. 27.
May it be please your lordship, today's fixed for case diary 439 bail application under section.
So it was for case record. Scan copy is there. 27. Okay.
Under section 22C and section 25 of the NDPS Act 1985.
It was supposed to be taken at 2. Now, at that time, someone has submitted that you are going to submit now. You are going to argue this case or?
Yes. Lordship, we are not prepared, Lordship, because we are going through one after another cases is there.
It will not be possible.
Not scan copy is there, Lordship.
Yes. Maybe listed on second, third PTRs. First, third, first, 3 and 4. 4 no more need to cook with eventually it will be very problem. I think first 4 first of October. List of list not first. Let me replace for morning hour.
Lordship, actually there is a reshuffle in our office, Lordship. All the LDs are reshuffled in FPP office. So, Lordship, they are unable to give us the collect the number of IO and to contact, Lordship. So they need some time. All new people are in the office. Lordship, I know about
reason behind.
For that, Lordship.
Yes, yes.
Lordship. For that reason, Lordship, we are very helpless, Lordship. All.
My lord, case diary is there, my lord, and my lord, petitioner is my lord, under apprehension. There is no any interim. May I pray for my lord, draw attention of the record regarding my lord, FIR, my lord. What kind of my lord, allegations before him?
Informant to lagi bono. Of
Regarding interim, my lord.
Otherwise, you were on that whether notice has been served or not.
Lordship. That IO's number they are not able to collect. They need only up till Monday, Lordship. They will collect the number. They have already collected some, but not all the PS. So they need some time.
By Tuesday, it can be.
By today itself, they will get. Tomorrow office is open, Lordship. So they will get collect by tomorrow also. So from Monday, Tuesday, they can give us the information.
Monday or by Tuesday.
Monday or Tuesday.
Can it be fixed on Tuesday? Tuesday.
No,
Monday, if it suppose
my lord,
some reason if it is not there. then
Tuesday we have another meeting, another matter, my lord.
Monday it may not serve your purpose. That's why I'm saying.
Lordship.
Wednesday is open, but open. Wednesday can be.
Lordship. Wednesday, yes.
Wednesday, what is the date? 25.
We are, Lordship, we are insisting as because we have no any interim.
No,
Yes.
this is a POXO matter.
Lordship.
POXO generally now say
POXO, but
POXO interim, it should avoid it.
my lord, so far, my lord, from face of the my lord, FIR, nothing is there against the just my lord, mobile number of the my lord, petitioner before your lordship.
No, see, let us see what is the
My lord.
then we'll build it. 25 minutes.
Obliged.
25.
Obliged.
Lordship, in regarding 44, Lordship, I am gone through, Lordship. His allegation was that Abdul Kalam Azad, one of his co-accused, Lordship, when he have misappropriated the rice, Lordship, for that, they have given a complaint to Sunil Kumar Das, who is before us, who is in interim also. He was the inspector of the food and civil supplies lordship. But as he have not taken any action regarding Abdul Kalam Azad, so the beneficiaries had and he's alleged his name also. And afterwards, he have given a report that he have filed a FIR against Abdul Kalam. Nothing serious allegation lordship against him.
No. What you have submitted? He
is the food inspector lordship, civil supply. This Sunil Kumar Das. When Abdul Kalam Azad, who was the IC secretary lordship, who have misappropriated the rice lordship for the month of July and August. Regarding this, they have complained to Sunil Kumar Das, Inspector of Food, who is before us today.
Who was the complaint against Sunil Kumar?
The beneficiaries. That the rice has been not supplied to the agent, they are unable to get the rice. Then, as he have not taken any action regarding Abdul Kalam, so they have alleged his name also that something is there between him also. Then later on, lordship, he have clarified that he have filed a FIR against this Abdul Kalam, and he have taken procedural against him. And in the meantime, he have got the interim and he have appeared before the police.
Abul Kalam is the co-accused.
Abul Kalam is the person against whom lordship the beneficiaries made allegation.
No. Abul Kalam is also one of the accused here.
Lordship, not
He is the accused person, lordship.
but he is not before us.
He is not before us.
He is not before us.
Yes,
He is
sir.
co-accused.
Yeah.
Yes, lordship.
Ah,
Yes.
that's what I-
Co-accused.
Without taking any steps against Abul Kalam itself proves that he is involved.
He is involved. Then lordship, he have filed. He have reported lordship that he have filed a FIR lordship. He have filed FIR against this Abul Kalam
Sir,
lordship.
really কি হবে? Already.
No, Lord.
Uh,
May I submit, lordship?
These things are going on.
this is the rice
The
lordship
items in which for the benefit of the beneficiary.
beneficiaries that they have said
misappropriated.
May I submit, lordship?
Is there any note from the IOS?
the last note is there lordship that he was not.
Any more? Here. Typing it. Here. What is the position of that state Abul Kalam Azad? He is already on bail.
Yes, lordship. Absolutely. Absolutely. Clear as well.
On third lordship, we have got the the beneficiaries. I have marked it lordship who have
his statement you have marked?
His statement, I have marked it. Like, last ending.
My lord, may kindly come to page number 22, the FIR. Against me, I'm not reading the entire FIR, plus paragraph, lordship. Hence, as directed, I lost this FIR against Abul Kalam Azad. This FIR was lost by the deputy director, page number 22, against Abul Kalam Azad, so and so, so and so, so and so, then secretary of Bagbur GPSS, Bagmara GPSS, and Pasim Mandia GPSS. Here, lordship, 3 GPSS are named. And request to take immediate action against the offender. And Sri Sunil Kumar Das, inspector, if he is involved in any criminal conspiracy. This is the allegation against me, lordship. This FIR was lodged on 8/7/2024. Now, lordship, here, lordship, 3 GPSS are named. Now, lordship, may kindly come to page number 25 for a moment. Page number 25. Earlier, lordship, I was the insert of 3 GPSS. On 17th of July 2023, I was discharged from the other 2 GPSS. Thereby, lordship, I was only the inserts of Paschim Mandia GPSS. Now, lordship, may kindly come to page number 34. This is the direction issued by the subdivisional officer Borpeta, page number 34. My lord, page number 34. To Sunil Kumar Das, that is the petitioner, regarding lodging of FIR against Abul Kalam Azad, IC Secretary, Paschim Mandia. With reference to the subject cited above, as per approval of the District Commissioner Borpeta, you are hereby directed to lodge FIR against Abul Kalam Azad, IC Secretary suspended of MS Paschim Mandia GPSS, as offence committed by him is punishable under Section 7, subsection 2 of Essential Commodities Act. As lordship, I was the inspector of that particular area, so direction was given to me to lodge FIR against him regarding Paschim Mandia GPSS. Now, lordship, may kindly come to page number 35. Page number 35, lordship. This is the FIR I lost. And the date is, lordship, 22nd of August 2023. I lost the FIR, lordship, as per the direction of the SDO, lordship. And so far as the other 2 part is concerned, lordship, may kindly come to page number 26. This is the inquiry report submitted by the another inspector Ajay Kumar Agoral, under whom the other two GPSs falls. This is the inquiry. He conducted the inquiry. It was the responsibility of this Ajay Kumar Agoral to lodge the FIR, if any. I have nothing to do, Lordship, with the other two GPSs. And Lordship, the FIR itself, Lordship may kindly come to the FIR for a moment, Lordship, once again. FIR, second paragraph, I am only reading 3 lines. In course of inquiry, the then Area Inspector Sunil Kumar Das and Ajay Agarwal has detected that Abul Kalam Azad has lifted. So, Lordship, 2 inspectors are there. One is me, another is Ajay Kumar Agarwal. The other 2 GPSs falls under him. That is not falls under me, Lordship. As Lordship, I am concerned with only Paschim Mandya. I have conducted inquiry. I have taken step. I have lodged the FIR. And on the basis of my FIR, Lordship, this person was arrested. Abul Kalam was arrested in my FIR, which I have lodged, Lordship. And so far as the other 2, Lordship, I was not there. And Lordship, the letter, Lordship, just now I have referred to, that is at page number 25, Lordship. That is my humble submission, Lordship. I have already appeared, cooperating with the investigating agency, Lordship. And Lordship, I will continue to cooperate
We are
with
on, we are on.
And Lordship, allegations, Lordship, entire
You are Mr.
allegations.
I.H. Rathban.
M. Ahmed.
Emma. Or Mr. Emma. But Emma is not in the they did it. The submit that presented no way or with any offense of disability rights when further after objective there is still he already appeared before the high and cooperate further discharging his duty as with respect and it was only he and TPS.
Yes, Lordship.
GPS.
GPSS, Lordship. Gaon Panchayat Samavay Samiti.
Only TPS of Mandya, Mandya West.
Paschim Mandya, Lordship.
Paschim Mandya was under his as well. Such the election of the right was brought and accordingly being inspected, he also conducted an inquiry when submitted it and he did so. He was directed that the authority concerned to laws and against co-accused Abul Kalam Azad, who was working as a he was the Abul Kalam Azad was
Abul
the
Kalam was the secretary, insert secretary, Lordship.
And according to the FIR was lost for 8% on the basis of it. The way it was also arrested above. However, it's very corporate. I got it. Its cooperation will be if it is required. I must give it in order of 3 years. He applied for the I according submitted that but he that because it is a food and supply sector at the time of incident when a complaint was made before him regarding appropriation rights for the beneficiary by the co-accused Abul Kalam. But only a just take it with it. Otherwise, it's other bit. Cooperation extended by the present government. I find that transportation your bail, interim bail was 5/8.
5/8, Lordship. 5th of August.
Interim bail dated 5/8. If they have to pay that.
Highly obliged.
Yes, I'm reading out the citation with para number. Yes.
One order.
Yes.
Any about this one. Yes.
State of Rajasthan versus Tara Singh, 2011, 11 SCC, 559, para 6. This is regarding when the samples were sent and all this. Then thereafter, my lord, yes. 2022 1 GLT 642 para 24. This is regarding safe custody of samples. Page 2022 1 GLT page 642 para 24. Then Mohan Lal versus State of Punjab 2018 17 SCC 627 para 8. Then person in whose custody samples on that ratio, my lord. State of Gujarat versus Ismail, ISMAIL, Smile space U, capital U, Haji, HAJI, 2003, 12 SCC, 291, para 5. Then regarding the Gudam register and this, Ram Karan, Ram space Karan versus State of Himachal Pradesh, 2008, CRLJ 44, para 12. Then they have not kept the seal in Gudam because the seal need to be kept in Gudam till it reaches the FSL, so that it cannot be tempered in other this. On seal, this is, your lordship must have read this judgment many a times, most frequently relied judgment. Noor Aga, NOOR, Noor Aga, AGA versus State of Punjab, 2005, 9 SCC, page number 777. I am relying on para 99 and 100. Then independent witness not supporting the prosecution case. This is a division bench judgment of our High Court, mutually destructive evidences. Suraj Gupta and others versus the State of Assam, 2013, 5 GLT 319, para 39. This is by Justice Ansari and Justice Indra Shah, division bench. Then 2021, 1 GLT 790, para 16 and 17. These two judgment will suffice. Then the burden as to how the burden of proof is to be discharged in an NDPS case, the standard of proof required. 2018 to SCC 305 para 5. Then 2020 9 SCC 202 para 9 and 10. Because, my lord, there is a reverse burden under NDPS Act. So therefore, my lord, I am relying on these judgments. The standard of proof vis-a-vis section 34 and 55. Then Sopan Mojumdar versus State of Assam 2018 4 GLT 448 para 17. And then Abdul Rashid, that's a very 2000 volume 2 SCC 2000 volume 2 SCC 513 para 22. These are all what I am doing. I'm done. I'm greatly obliged.
Well, I shall be precise as possible. Well, so far, seizure, it has been contended that seizure is not proved, or in many cases. But seizure has been proved. Then in respect of seizure, PW1 has been duly corroborated by PW2 and 3. PW2 and 3. PW1 has been corroborated in respect of seizure by PW2 and 3. So seizure is proved, my lord. Now, my lord, my learned friend has asked that seized ganja was not physically produced before the court. On that point, I submit section 52A is not clear after seizure, but for the reasons stipulated in the section 52, that can be destructed after drawing samples. So nothing illegality is there. And in the meantime, inventory has already been prepared, and that is duly certified by the magistrate. So there cannot be any doubt in respect of seizure of the ganja. It has further been urged by my learned friend that superior officer was not informed in compliance with section 42. My superior officer himself was present. SDPO himself was present. What further information is required? Now, regarding section 52, what was learning?
No,
one.
Hand recovery, body recovery.
The body search for body search for
Body search for 50.
That is all right. He has not asked that point. Now,
57.
Now, time,
57.
Not time gap between that after seizure, in whose custody it was there, who was in charge of the Malkhana, all these things were not raised. But all these things has not been confronted. PW10 has not been confronted with such time gap. During the cross-examination, no such suggestion was made. Now, from the evidence on record, it appears that the seizure was made on 24th in the evening. It was handed over to the officer in charge on 25th. And as per experts' evidence, it was received by him on next day, 26th. And police station is Bizni, 165 kilometers from here, and FSL is here, Kahilipada. So during this period, no such cross-examination on this point. Who was the custody? Whether he has recorded all his statements of these persons to whom he was handed over the. It was evidence. It is evidence on record. My lord. After seizure, it was handed over to PW10. And thereafter, after drawing sample, my lord, it was sent on 26, my lord. So I do not think that this time gap will create any doubt in the prosecution case, my lord. So with all respect, I submit, my lord, the case, prosecution case has been proved beyond all reasonable doubt, and there is no scope for any interference by this honorable court. That is my answer.
30 seconds, only 30 seconds, one thing I'll say, that the learned public prosecutor said that there's no cross-examination. My lord, whatever little I understand trial, why should I cross-examine a witness regarding something which is he not said? If I would have been the trial court advocate, I would also not cross-examine on point which he has not said in evidence, because it is for him to prove the compliance. And then another thing, that SDPO was present. I don't find the SDPO as a witness. Why he has withheld himself from the witness box?
The entire search and seizure was done presence of
SDPO, he's not there.
No, SDPO was there.
No, he SDPO's witness, he's not cited as a prosecution witness. So he should come and enter the dock and say. And my lord, that SDPO not examined and not confronted, my lord. My lord, the art of cross-examination is this, my lord. Your lordship has ample of experience, my lord, in the trial court. If a witness does not say something in chief, why should I poke him with those questions? Normally, no advocate will ask him those questions. It is for them to prove the compliance, not for me to prove. They are the prosecution. And these are the precise things, cross-examination this. So admittedly, my lord, there is missing link evidences. Okay. I'm obliged.
Lordship,
You are on 19?
No, Lordship.
I told you.
Very sorry, Lordship. I beg to mention item number 35, Lordship. I was sitting here for long, Lordship, to do my case, to do my item 35. That has been, Lordship, called for in the past, and that has been already been, Lordship, adjourned and fixed after vacation, Lordship. Can it be possible, Lordship, we could go any date of the vacation?
After vacation. 35.
No, it's bail matter. Can it be possible before vacation? Any date, Lordship?
No, most probably no. Because these are all NDPS matters. It takes time, and this bench is not sitting regular. It's not a regular bench, because from next Monday, it will be another bench. So, I don't know. It will be after vacation.
Well,
the commercial.
I'll submit the problem.
Obviously.
Non-appearance
19 and 20. 19 and 20. It will come after vacation.
Non-appearance will be a Lordship. That means
What to do? They are not appearing.
I was lagging another court.
Okay.
Thank you.